it's rather, you know, housekeeping. So I think we'll let them in already.
We're starting to letting them in.
No.
Edgar, guten Morgen.
Ach, guten Morgen. Ja.
Wieder.
Guten Morgen, Udo. Hallo.
Hallo Christian, morgen.
Endlich mal wieder am Bildschirm seit Freitag.
Ja, ja, Gott sei Dank. Ne? Gott sei Dank.
Deshalb weiß man doch, was man hat am Tag.
Hat jemand von euch den aktualisierten Zeitplan jetzt?
Nee, ich habe es mir gar nicht mehr angeguckt. Ich denke, das ist, wie es ist. Ne?
Nee, er hat gesagt, es hat sich irgendwas geändert.
Ja, also wir
Dr.
fangen
Meyer, I'm glad to see you with us. We already let people in, so we have the participants from our side continuously connecting. So when there is some critical number, I will start our introductory part, and before that we can, you know,
Okay.
Good morning.
Morning.
just to say good morning to each other.
Jury, just for us, and as Udo has just joined, order will be, can you just give us, and especially Udo has just joined, the order of the topics that we...
Yes, yes, you'll see it right now.
Okay, good, fine.
I think just 5 minutes to have more people joining us, and then we'll start. The rate with which we have new connected people is rather high, so I think we will start within 5 minutes.
You have an impressive number of participants for your
Yes.
session, really. So there is obviously there is a need for more knowledge about the topic.
Absolutely, yes. Christian and Heinz is joining us for.
Yeah, so I think he's not here in the Munich office, so I think he's sitting.
Yeah, we still have 10 minutes more.
Yeah. So actually his picture just means the setup.
So, okay, we start. I see that number of people raises every second, and therefore it's time to start. Я начну. I will start with Russian for some very short introduction and then switch to English language. Уважаемые коллеги, я рад вас приветствовать на нашем семинаре «Стратегии защиты охраны интеллектуальной собственности для успешного развития компании». Мы начинаем нашу программу. Она у нас сегодня насыщенная, интересная. И как мы вас и предупреждали, учитывая, что мы будем говорить о охране прав за рубежом, мы будем говорить сразу же на английском языке. Во-первых, это нам существенно сэкономит время на представление материала, потому что любой перевод, он будет его отнимать. Во-вторых, адекватный перевод достаточно сложен. Ну и, может быть, хотя я это говорю третьим, но это, наверное, самое главное, что большинство из вас все-таки в достаточной степени владеет языком, чтобы понимать, что будет изложено в презентации, что будет письменно изложено. Наши участники, наши выступающие будут стараться говорить не быстро и понятно. Мы не имеем среди нас жителей Великобритании, чтобы мы их вообще не поняли. Поэтому мы потихоньку начинаем, и я перехожу на английский язык. So, good morning, our dear attendees. We are glad to see you here and to start section 1 patents of our seminar, of our annual seminar, Strategies of Intellectual Property Protection for Successful Development of Companies. This is a remarkable section and remarkable day because we were thinking for a number of years how to enhance our seminars and how to add them by much interesting information. And the only way to do that, of course, was and is to expand them to other countries of the world, because the IP world is a sort of mutual contributory world. Legislations are harmonized, the approaches are in much taken, the most successful of them are studied. And by this section, by this day, we open our new educational project, which is which we called IP Practice by Countries of the World. It is a study of various IP aspects in selected countries. This is our selection. It is not only about law as such. It is not only about procedures. I would rather say that we want as much as possible leave recitations of the law and procedures away from our seminars, because you easily can read that. And the countries are selected based on our clients' interests. And of course, that interest is added, the selection is added by our own selection of the countries based on the role the countries play in the modern world IP turnover. We are playing here in those webinars seemingly passive role, because we will act mostly as moderators, as active moderators who will ask in questions. Of course, we prepare those questions, but our speakers, main speakers, will be leading professionals in their in the IP field, in the patent field, with which we start later with the trademarks and licensing, although we have licensing, excellent licensing professionals today as well. We ask and we received confirmation from those speakers that they will be sharing their experience. Perhaps they will share their thoughts they never shared before. So we are lucky to have them in such role. They are invited to speak, to comment, to discuss various topics with you and answer your questions. How it will happen today and further? We plan to devote one seminar to one country. First, as this year, we have only one day devoted to that country practice, but probably we will expand the whole days of our seminar to that country, covering more institutes of IP, more than just patents that we do today. We will combine presentations and roundtables. Roundtables will allow you as our listeners to become active participants, to discuss and ask questions. Working language will be English for all further seminars. And be ready for that no translation will be presented for the reasons I said in Russian language before. First country we start with is Germany. Why? Lots of reasons. Lots of reasons. Significant role of IP in economy in past ages and now. You all looking into history can easily find the traces of German technology, the traces of German specialists, professionals in Imperial Russian industry and in Soviet as well. Business connections with Russia. I would say that my impression is that Germany is the country with the strongest business connections with Russia, was and still is and will be, I think. Technological transfer, which goes all the way. And during the Soviet time, it was both with Federal German, Federal Republic of Germany and German Democratic Republic. And those of you who are approximately of my age can remember the seminars of the former countries of the so-called Union of Economical Mutual Assistance, SEF countries, where German Democratic Republic played always leading role in IP. And most common in patent systems, and those just a few reasons why we selected Germany. Let me introduce the rules of our event, although I will repeat them from time to time in each of my roundtables for sure. Topic is proposed by me and other moderators. Moderators and panelists discuss this topic. You may ask questions. Please write them in chat, and we will group them and select the best way to present. Then moderators select questions for discussions and time to discuss them. And since we are anyway limited in time, the discussions can be terminated by the moderator, but can be continued later after roundtable ends. Approximately 10 minutes we will leave every time when we finalize the roundtable to discuss them, in live mode, and you all feel free to contribute, although we allocate approximately 2 minutes for each, contribution or exchange, because anyway, we're limited in time. This is for our live event. Of course, you are free to write the questions for us, and we will then separate them between our speakers. Disclaimer for entire event. As patent attorneys, as lawyers, we do disclaimers every time. And the first one is, although our invited professionals are, I would say, outstanding professionals in their fields of arts, in their companies, and lead the IP practices, you should not understand their positions as immediate and privileged legal advice to you. Because this is a discussion. And this is not because we want to earn money for them, but because legal situations are only seemingly alike. If we look at them, they are seemingly all about the same, but what play critical role are lots of minor peculiarities and nuances in them. And we are not able to, appreciate all those differences in such topics. And because of that, usually in the legal situation, in any legal situation, there are more than one way available for solving a particular legal problem. And the task of a professional advisor is not to select it for you, but it is to explain you the ways in which you can solve this situation, giving you explanation of the benefits and drawbacks of as well of their consequences. But the final decision always leaves with the IP holder, not the advisor. With all that, we start our program, and we start it by introducing the topics and the speakers. The first I did that in the alphabetical order, but Mr. Gadar, I think everyone will agree with me, so outstanding that we announce all the speakers starting with him. So Professor Gadar, raise your hand, please. Professor Heinz Gadar, I cannot say is the oldest among us. He's the most experienced by age among us, and he's in IP area since 1972. So I was 4 years old when Mr. Gadar started his practice. And that time he was admitted to practice as German patent attorney, then as a patent attorney in Dortmund to Dortmund, one of the leading German IP practices now. He is honorary professor for intellectual property in University of Bremen, a lecturer in whatever universities known in the world which speak about IP, which teach IP, and IAM IP Hall of Fame from 2014. Very impressive. Then we go in alphabetical order. Christian Appelt, German and European patent attorney. And for us, he's also very interesting because he has significant in-house IP practice. So Christian, will play a dual role today. He will play for both teams, for in-houses and outsides in our second round table, which we all will be very interesting. We are very interested to see that play. In IP area, Christian is from 1995. Dr. Edgar Dussel, I think the highest ranked acting IP in-house among us right now. He is the senior vice president for intellectual property with Schaeffler company, and Dr. Dussel will specifically tell us more about his in-house IP practice when we reach that topic in our second round table. In IP area, Dr. Edgar Dussel from 1992. Mr. Udo Meyer, formerly head of IP department of BSFE, but I think BSFE, BASF is such outstanding IP practice that you never become former even when you leave BASF. It lives with you forever. So forever BASF head of IP department, Mr. Udo Meyer, German and European patent attorney in IP area from 1991. So our dear listeners, you have today board of people having about 30 years of their valuable lives spent or sacrificed to IP field. So you certainly need excellent selection. I'm not speaking about Heinz who sacrificed almost all my life to IP, I mean in duration. With all that, we start. Our today program starts with roundtable. You received our preliminary program. We specifically wrote that it is preliminary because you have here all acting patent professionals, and it is always difficult for them to devote so much time from their professional schedule to that event. The only reason why the only way to make them doing so is to grab them and have them here in Moscow. But unfortunately, due to pandemic situation, we weren't able to do that. And therefore, please excuse us for some, shuffling the events. We did lose any one of them, but we put them in another order. And that is because being in Germany, being at their working places, they have what to do. And from time to time, we will see some of them will disappear, but then appear again. So we start with our roundtable ideas on PCTUs, national and national patent route versus EPO route, pros and cons, upcoming community patent. Then we have roundtable on IP in-house patent departments in German R&D and manufacturing companies, the ways to cooperate with outside consoles. Then we have break. It is 15 minutes break, but my advice to you is do not waste it. Write your questions. Write your questions. We will group them. We will prepare our today's speakers to respond to them. Afternoon program will be roundtable on place of Germany in the global technological development society, university inventions and license and practice, and then questions and answers. I very approximately allocate half an hour for that, but probably we will be able to devote more. With all that, we start. Patenting in Germany and Europe, national way or European patent system. Rules of this roundtable are similar. You just look at them to refresh what I said you 10 minutes before. And again, the disclaimer, although our today's speakers have excellent and enormous, I would say, experience in using whatever systems of patenting in Germany and the world, you should not understand anything that they say as immediate and particular advice to you how to build your patenting strategies. Started from the very beginning. What does patent give? Any patent, and sometimes people forget about that. The patent is not something that permits you doing something. Although many legal acts say what first is given patent to its owner is right to use the invention. No, because let me say no, because you may use your invention even not patented it. And needless to say that many companies, many people do that. They don't patent invention across the whole world, although the inventions may be very important, but they just use them. What any patent gives is a right to restrict anybody from practicing what is patent protected. It is very, I would say, very strong monopoly, because a right to use something can be given to as many people as possible, but the right to restrict anybody can be given to just one. And that restriction works within particular territory during a limited time frame and in a scope defined by patent claims. What we get with a patent, we get exclusivity on market. Exactly, no one can practice what we patented without our permission. We get right to license invention, thereby giving another party exclusivity to practice. We receive a right to demand anybody to stop doing the same as we do, as patented, by infringement litigation. And assuming we have an invention which is patented in Russia, and I intentionally put some questions very provocative, and we do not care that somebody manufactures it in Europe without our permission. We have little expectation of licensing it to some entity in Germany, let's say right now. We do not trust in German judiciary to go in infringement litigation. But we want to use our invention in Germany. We want to import, manufacture, sell, further develop it. Would you recommend patenting this invention in Germany? So we start. Who is the first? Heinz, I think we start with you.
What do you recommend patenting this invention in Germany? I think before trying to answer this question, or at least to give you my personal opinion, cordial thanks to the organizers, particularly Yuri and his partners, Ingo and Partners, to the co-speakers, and briefly mentioning that actually I do not work in IP only since 1972, but since 1970. But in 72, I was admitted to practice as a German patent attorney on the 1st of September. But anyway, that is only something which I don't usually omit in my in my CV. Would I recommend this? Yes, for a simple reason. We must first look at the role which patents in the modern world play. I was a few years ago invited in Singapore at one of their famous IP conferences. They have every summer Singapore IP Week, to talk about a theme which was imposed onto me. It was not invented by me, so I liked it a lot. Namely, patents hyphen the currency of modern trade. And patents are indeed somehow the currency of modern trade, namely for two reasons. First of all, you can, as Yuri just has explained, use patents to exclude others, nothing else, from the use of what you have invented. So first of all, to make out of an innovation which you have made in Russia or wherever in the world, before you make something like a tradable good out of it, you have to make sure that without restriction, that somebody steals what you have innovated, copies it in an unauthorized manner wherever in the world, and you erect for that purpose a wall consisting of also other intellectual property rights, but essentially of patents around your innovation. Now you have a protected garden in which you innovate, you grow wonderful flowers, your inventions, your innovations, and others cannot just use it in an unauthorized manner because there is the fence in between, which consists of patents. So you keep others out. And we find the role of patents best described, I think, in TRIPS, in the trade-related intellectual property provisions of the International Agreement on Trades and Tariffs of GATT, namely that they prescribe first to erect the fence, which is the base law of all patent laws in this world, and also a very important Article 7, which says why you have to do this and why practically the OECD countries, including Germany, forced practically the emerging economies, particularly in the southern half of this world, to accept strong patents and the possibility to have these fences by saying this is all for the purpose of promoting and enabling and promoting technology transfer. In other words, the patent system has two tasks. First, to solicit investors into the garden to grow protected innovations which you have surrounded by a fence. That means you can, wherever you have a patent, you can get higher prices, you can get higher return over your investment, what they call it in economics usually. And secondly, there is the provision, otherwise the patent system would be useless, that you share the innovations with others. And this is the prescription of Article 7 and 8 together, actually, of TRIPS. Whether the industrialized world, particularly the OECD countries, including my beloved Germany, have fulfilled that task, the promise to the third world, namely to share sufficiently in the past, particularly also whether they are sufficiently sharing today, is a big question. We have these discussions concerning COVID-19, whether this should be given for free. I don't think so, because that would mean no fence anymore. Or they should give it through certain conditions to the third world is still the question. But coming back to my thesis or my starting point, the patents give the possibility to share innovations with others. You can send the package consisting of the fence and the content of the garden to other countries. You can license it out. You can have a door there, which under specific conditions you open so that licensing becomes possible, because what I'm describing here is just a license scenario. But at least you can now go to others and say, look, I have something which is protected for me. Would you like to use it? Many people would always say, no, I don't like to use it. And that would be the problem here with patenting of your invention in Germany. Probably it will be very difficult to go over this hurdle as an innovator in Russia, and it applies to all other countries and also to small and medium-sized enterprises in Germany. The most difficult task for an innovator who wishes to use the patent system to somehow make use of these possibilities to earn return over investment, to earn money out of it, and on the other hand, to share it with others. The biggest hurdle for me, I would even say, is not to make the invention. It is certainly not to patent it. A capable patent attorney in Russia, for example, I know it personally very well, is full of very capable patent attorneys. For such a patent attorney, it is usually not a problem to get a good patent on a good invention. The hurdles at various patent offices in this world are of different height, but good patent attorneys will know how best to maneuver to get patent protection. The biggest hurdle comes then to find somebody else who is willing to fill some money into the hat which you are holding in your hand when you open the door in the fence to let others enter your garden, use your innovation at certain conditions. To find somebody who wishes to pay for what she or he wishes now to use. And this becomes now the interesting question, what is good if you patent in Germany? If you patent in Germany, first of all, you can prevent German interested parties, other parties who would like from other countries, whether it is mainland China, whether it is Taiwan, whether it is United States, who wish to use your invention in Germany. Germany is then, by your patent which you have there, closed. By having done this, you are also making use of a very specific aspect of the German patent system, namely that it factually and practically, in spite of the recent softening of our injunctional, I would say, remedy, which you can get from some patent infringer, from an unauthorized user by our so-called second patent modernization law, is a country where the interpretation of patents is, the scope of protection is very broad, and secondly, injunction comes very quickly. So if you have a patent in Germany with courts which act very quickly, you can very easily others keep out from the use of your invention in Germany. Maybe that is particularly for pharma industry, for industries where you have practically one patent protecting one product against unauthorized imitation, etc. That is what you wish to achieve in Germany. But if you are in an industry like in the modern ICT world or in financial instruments, where patents play a tremendous role, which usually is not seen so well at the surface of what is happening worldwide in the patent system, you will see that in order to be yourself able to use your invention in Germany, though the patent does not protect you in the manner that it would allow you to use your invention in Germany, you only can exclude others. You will find that the field in which you work as an innovator, a Russian company, is full of patents of third parties. If you are in a certain telecommunication standard, you will all of a sudden have to create somehow freedom to operate under, I would say for 6G, you will have about 10,000 patents of others, which you have to avoid in order to use your invention yourself in Germany, or which you need to get free of in order to be able to license your invention to others for use in Germany. So freedom to operate plays a tremendous role. And here comes now the patent as a currency. If you have yourself a sufficient heavy, rich portfolio of patents in Germany in the respective field, you will use it to buy freedom to operate. You will possibly, or your licensees will possibly in Germany be contacted by one of the big shareholders in, let's say, telecommunication patents in this world. Number one, probably nowadays, Huawei already, next one being Qualcomm, next one being Ericsson, then Nokia with a little bit, still a respected portfolio, but these are big players. There are other names. I don't wish to mention them all here. But if you go to them and say, if they come to you and say, look, you cannot use your invention in Germany and your licensees cannot use it in Germany because your products, your systems, your telecommunication devices, your methods in which you are transmitting data or whatever, infringe our big patent portfolios, you will see if you have a patent, particularly if you have many patents, a portfolio as we call it, you will say, wait a minute, let's not talk about my products and my licensees' products so much. Let's talk about your products and your licensees' products. And we come out with the knowledge that they infringe and unauthorized manner, in an unauthorized manner, use your patents. And then a deal is the necessary thing which is necessary, which is on the table. That means that you can, by patenting your invention in Germany, create freedom to operate for yourself and for your licensees to do what you would like and they would like to do in Germany, which, by the way, is still a member of the European Union, as you know, and you can buy freedom to operate without risk anymore in future to be molested or touched upon by the patents of others. So yes, I would recommend patenting in Germany, and particularly in Germany also for one reason. If you look into the European Union, we might have in future somewhere a so-called unified patent court.
And we will talk about that. I asked
I'm finished.
because we have to move ahead.
I'm finished.
Yes,
I wanted
yes.
only to say that in Germany, you will have a good possibility to enforce your patents and to keep others away from the use of your invention.
Heinz, you convinced us all, and I think we are now ready to do to include German in our first plans. But we need to draft a patent application. We certainly drafted first, as you know, aimed at the Russian Patent Office, but probably we do that incorrectly with when we aim at the Germany and the European Patent Office. Christian, may I ask you, does any specific exist for application drafting when we aim at patenting through the German Patent Office or through the European Patent Office?
Yeah, of course. I mean, nevertheless, Yuri, although you have stopped the topic in before, and let me shortly emphasize on the topics. Can you give me 2 minutes probably to the slides and beforehand? I think it's quite important that everybody knows patent is really a business tool. That's what it's all for. You have to keep that in mind. It's not for honor. It's not for nicing something rightly, but it's a business tool. And the question Yuri has asked in beforehand, if you want to use in Germany to manufacture and sell, you probably would not care for patents, but your competitors will do. And I think that is an important thing for you to know. And Germany is clearly the core market. And frankly, I just raised the one question Yuri has mentioned. Well, even if we or somebody else or you do not really trust infringement litigation proceedings in Germany, and I fully understand for each company, for each institution, patent litigation is the worst thing that can happen because it disturbs your business. So best thing is you don't have any patent problems, but you can sell your products, but others will use that tool, and it's extremely effective in Germany. It's fast and very effective proceeding in patent litigation. So patents do play a major role in Germany and therefore also in Europe. Now coming directly to your question, yeah, well, it would be too easy if there would be just one route. There are many possibilities to finally get patent in Germany. And Yuri has just explained 2 of them. We may come to others later during the stage, patenting through the EPO and patenting through the German Patent Office. Actually, drafting of the applications from my perspective is exactly the same. So you don't have to draft separately or differently for EPO than for GPTO. And even if I would draft, I could make the decision to file at the EPO or the German Patent Trademark Office shortly before filing. set aside probably the language problem. But I think what is the most important thing for you, the first drafting and filing of claims, and that's true especially for EPO, but probably on the same level for German Patent Trademark Office. Do this right. Yeah, you place the most important aspect of your application at the beginning. If you do something wrong, if you miss something, if you formulate something wrongly at the beginning, you will hardly be in the position to repair that. So put the most effort, and I think that's the most important information I give you. Whenever you need assistance, if you want to invest, you have a certain amount of money to invest in certain issues. You have to take care of that, but put it at the beginning. A wrongly drafted set of claims will, and presumably, in many cases, destroy an effective protection for you in many, many countries. So the starting point is the most important one. And then you can think, and if you look into Europe, certainly number one would be the German Patent and Trademark Office. And if you have less money to invest, if you have a focused goal, then you probably go only to Germany. If you want to consider more countries, you can go to EPO, but that's essentially a cost factor because procedures at the EPO, and that's not your attorneys, procedures at the EPO are remarkably more expensive from official fees. So you may have to select, and it's always for your business decision.
Thank you.
Probably I'll stop here.
My next question will be mostly devoted to Dr. Duschel and Dr. Meyer, because we as outsides already started separating us. We face just what is written in the first pages in the petitions of the patent applications, but we don't question how that happened, that some people were added to the list of inventors, or some even as the applicants. Let me ask you, inventorship and assignment matters. In Russian practice, they are very often taken too easy. So non-contributed to invention people are added as inventors. Some contributed people are, for whatever reasons, forgotten to be added. Applicant patentees assignments, especially of service inventions, are not supported documentarily. This is, by the way, why I'm devoting this question particularly to you. How critical such matters are for validity of patents in Germany, including those which arose from the Russian patent applications? Dr. Duschel, Dr. Meyer, who will start first? Dr. Duschel.
Yeah, I can start at this point. I think first, if you look at this matter from a perspective of German law only, and I'm employed with a German company, then for the first thing, what you always have to make sure is how the owner of the idea originally is the inventor. And we as German companies have to make sure how we can transfer the right on the invention to the company. So that's a very important point, just to make this sure. And this is quite a formal act which we have to follow here in Germany. And then after that, the applicant, which probably then is the company is allowed to file for the patent, and the inventor has the right to be named as the inventor on the patent, but has no real right on the later patent. So from my perspective, the question of naming the inventor is not so much a question of validity of the patent, but more a question who is the owner of the right. But at this point, I'm really happy to hand over to Udo, who may add some sentence here. Yeah.
Yeah, sure. I fully agree to what you said. The only validity problems we had in the past were in the US. When you go into litigation, might become an issue whether or not you have named the wrong and not the true inventor, as it's called there. It's not so important in Germany, I think. But there's another aspect. We have a strong remuneration right in Germany for the inventors. So you want, as an employer, you want to make sure that the money is really paid to the right inventors and not to someone in hierarchy being in the R&D organization and saying, well, you know, I'm heading the R&D department here, so I'm always an inventor to each and any invention made in my department. So this is wrong. This is really nonsense. And this is something you should take care of in a company to really have a process, as Edgar said, where you try to check who really contributed to the invention, or where some may be forgotten. Some technicians, for example, this happens again and again, who really contributed seriously to the invention, they can't be forgotten. It's not a matter of people with a PhD in chemistry who can make an invention. It can also happen that others were involved, even people giving ideas from practice, from the business. So this is something you should take care of, maybe less for legal reasons, but definitely for having a smooth process and for having the inventors satisfied with the list of inventors given on the patent.
So I would, yeah, if I may add something here.
Yes.
So if you would sum it up, so the question of validity of the patent is not so much a question of are the inventors named correctly. The main question is the applicant the owner of the application? And there are really some tracks, you have to really carefully follow up this. So you may think that you are the applicant, but it might turn out that during the process there were some formal mistakes which in the end show that you're not the legal applicant, and you may have to transfer the patent to the person or the legal entity which really should be the economic owner of that.
Yeah, and let me also add something to that. I think what Edgar Duschel just said is extremely important. So when you file a patent application, at that stage, you must be entitled to file this application. That means before filing, not thereafter. And the question, Yuri, you raised, is that critical in Germany? As far as I currently see, not that much. But if you just look into the last 3-4 years, probably at the EPO, there have been a lot of case law about this, whether, for example, if you have a first application in Russia and then you go into a second application, probably in between you have transferred it from an inventor, from a research company to somebody who then will do the business, and you want to have him as a patent applicant. So whenever you have assignments and transfer from the inventors to a company, or from one company or to another company, or, and I understand a lot of people are involved in research and institutions, you have probably cooperations. You may have inventors of different companies. So make sure that who at the end files and is the named applicant, that he has the right, that he has collected the right from all inventors. So that is a critical issue. And I think, as Udo has mentioned, it all comes up not at the beginning. The patent office will not check it by themselves. They have no possibility. They will not do that. So it comes in by third parties, and it comes always in when the patent is valuable. So in a situation where you don't need it. So make sure that you have the basis for that and that you have some records to prove it upon request.
Great. So we are moving forward. We decide to enter Germany to get a patent. But let me ask you in a sort of blitz questioning, allocating only 1 minute to each of you to one question, which is asked very frequently. And here is it. How soon international patent for invention will appear? Who starts first? Heinz, just 1 minute.
Yeah, if I understand the question correctly, how soon will you need to go into some kind of international patent application. The binding term is always the 12
Soon
month
you will be able to
priority
find just
period of
one
Paris Convention,
application
period.
to get protected all over the world immediately as by one patent.
You need within 12 months after the original filing date, let's say in Russia, you need to take steps for international patent application.
Oh yeah, okay. So this question is so frequently asked here because majority of people think that after they filed PCT application, they are to expect one single patent covering the whole territory of the world. And my question was a sort of provocative. So why it hasn't yet happened that we can file one application and cover all the world by a patent application for invention? And when can we expect that such situation will come up?
Let me start with a provocative answer. Never, Yuri. It will never happen.
Right.
Very simple.
Agreed.
Not in our lifetime.
No.
And
Everyone
the reason
agrees?
and you asked for why is because there are 150 countries involved and nobody will give up jurisdiction about its own country so easily.
Of course.
Great.
I
So
think
go
we
ahead.
I think with the PCT system, we already made a big a big step forward. So I think you always have to make clear yourself. So dealing with PCT or international patent applications is just a simplification of the application procedure. Though there is one spot where you can file one patent application for many countries. But you have to decide during the run of this process in which countries do you really want to have the patent prosecuted, and that's an individual discussion with each individual country at later. But the international community could just agree on a common application process, but not on a common patent prosecution or patenting process later. So, and I completely agree, it does presently not appear that we will end up.
We all are united saying never, and go ahead. So since never, we are such alternative, we have such ways to enter to get patents covering German territory. We can cover it by European patent, German national invention patent, German national utility model patent. And of course, we can do that starting from Russia by so-called conventional filing, where we need to file all patent applications within 12 months from the earliest priority date, or through PCT system. And I would like you to tell us, to describe what benefits does PCT system give for patenting only through German Patent Office or only through European Patent Office. Of course, with your preferences, how to approach to this topic. And here we have two contributions by Christian and by Heinz. Since I am the leading person in that our discussion, I will change the slide. So please ask me when to change to the next slide. So Christian, it looks like this is your contribution starting. Sound, please.
Yeah, that was just a picture to give you an overview how many countries you cover by PCT. But I think the most important aspect we've just heard, yes, you can file an application at one step, and that's very helpful, but just a foot in the door. You will never get a patent granted in all of these countries. And secondly, you will never have much money enough to do so. So what you do is buying time. Here's a procedure you have to take into account. So you start at the beginning with a national patent office, and that may be typically your home office. It could be also Germany, but it's normally a first starting office. Then you have the timeline. You have 1 year to think first what to do. That means you can, within 1 year, without losing something, without going into detail, that you claim the priority of that first application. And then you have to go either in all countries you want to select, and you've seen there are quite a lot, 153 at PCT, and there are another 20 which are not members. So we have about 170 countries all over the world. So you have to make selections. So, and then you go either to each of the countries, or, and now it comes secondly, you know that you're already interested in a group of countries, like at the EPO, and that's a step where you can really get a patent granted, so remarkably different to PCT. So you have one procedure and you can end up with one patent for 38 plus 4 countries for about 42 countries. Or you go into PCT, but that is just delaying of time for making a decision. So I think the crucial point comes about in the middle where I've mentioned Paris Convention, where you have that 1 year. So you start with the first application. Again, make sure that the first one is very properly drafted, because you have to have the disclosure content there. What you have not properly defined in patent language term will be lost for all future, for all proceedings thereafter, actually. And then after a year, you have either two positions. The one is, I know where to go. I know my countries of interest. So I would really say, think, focus where your business is. And that's your only point. Where is your business? Where do you want to make money? If you have a clear decision, and that may develop, of course, over the year, it may also depend on the one or the other situation and also the application and the technology. You can select specific ones. You can, for example, go directly to Germany. And if you know in Europe, I want to have Germany and I don't want to have the rest, or I cannot afford the rest. If you know I don't want to go into another country, then the question, and this was what Yuri has probably asked, do I need PCT? I would say no. Why? Because PCT is additional money. It always comes in addition. And then if you go to Germany, you have exactly the same amount of money you have to invest again. So it will not save money. So point is, you know where to go, then you go to those countries where you know, or you don't know, and that maybe also happen in some cases, or you want to have flexibility for future, for licensing, etc. You don't know in which countries your patent may be valuable as well. Then you may consider PCT filing. You keep options open, or for Europe, the same thing. If you know I just need Germany, or probably I just Germany in the second country, it would be more cost effective to go into Germany and UK, for example, just to name two, or Germany and the Netherlands, or Germany and France, depending on your interests and your business. If you need more, if you want to have the flexibility, then you go to EPO, but it's essentially a cost decision. So think, focus, and make clear decisions at first filing, after 1 year, and then probably only if you're uncertain, or if you want to buy time, or if you want to keep licensing options for the future, then you may think about PCT, but it's in addition. Does that help as an introductory part, Yuri?
We are seeking for patent protection in Germany, so finally we come to Germany by either way, by European or German. So what is going on then?
Shall I continue? Was that to me, or yeah?
Yes, that's
okay. So that was possibly the point I've just mentioned in beforehand. If you're thinking now about the European market, so that thing. So you're focused already. We're not worldwide. We're thinking about the European market. That's a coverage of the European market, which on the right side, where Yuri has its hand, already even goes to Cambodia. Probably not the most important thing. Right. So consider the red ones. These are 38 member states. You get the patent granted at the EPO for all of those states. And then you can probably show the next slide, Yuri. Point is, you see on the yellow side, this is what you're all doing at the regional phase. So contrary to PCT, where it's just filing, there it's filing, we'll get search and examination, and you get a grant of a patent. So that will be all done by the European Patent Office. And then we're talking about the EPC system. Then we will fall into a bundle of national patents. It will really fall apart into 38 parts, which are all then as a national patent. And depending on to which country you go, you probably even have to initiate some steps, like, for example, translation. So it's not yet for free. Also, this is not a unitary patent. So what Yuri has mentioned, there is not an international patent that will never come. We currently do not have a unitary patent which covers all Europe, but it's still country by country. And even in that validation step, you will have to select some of them because you have to pay renewal fees. It's again a cost factor. So even with the EPO and the EPC system, you have to make a final decision in which countries you want to maintain the patent, but it's granted by EPO. I don't know whether I already should refer to that European thing, to the unitary patent, which is about to come. So here I would say, well, 2022, 2023, probably it will be a start. Then you will really have the possibility that you have a unitary patent. And now it comes for most parts of Europe, notably not, as you all know, for United Kingdom, because due to the Brexit, they have stepped out. So still it is not all over Europe, but that will be a unitary patent. And this is about to start. But again, important for you, you have to make the decision first. Oh, fine, thank you. Yeah, so you have to make the decision first, where to go, and what are your important factors. And I think, Yuri, what you have introduced there, kind of a few comments for procedural aspects. Shall I refer to that directly as well?
Yes.
Yeah. So we have come, that was coming from your side, Yuri. What do we have? Do we have differences between Germany, European Patent Office? I think I start with at the beginning. For drafting, no, just make it good and make a clear decision and clear definitions that you cover everything. And frankly, if you are not very well experienced, you need support for that. So make your investment at the beginning for proper drafting. I think what is same for, and now I'm talking about EPO in Germany, 20 years from application, that's identical. Admissible subject matter, what you can file for patent, what you can protect by patent is also the same. Unity requirement, I don't know whether that means anything to you, as sometimes you have a couple of inventions which are closely linked and you don't want to write 20 applications for that. So you want to cover, frankly, multiple related inventions into one applications. Can you do so? Yes, you may try and cover it. At EPO, it's more strict than at the GPTO. You will get at the German Patent Office, you have more possibility to cover related inventions into one applications. Then I probably jump to the right side. That's of course important. Costs, as mentioned, for the attorneys and whoever is working on that invention, made in-house, made external, that doesn't matter. I think that's about the same. What you're thinking about as crucial factor is the official fees, which are at EPO by factor 6 or 7 higher. And you can see, you can easily add Germany and another national country, and you're still from official fees cheaper than at the EPO. If you need protection, let's say in 3-4 countries, then probably EPO will getting better. German utility model is actually kind of a cheap system because there is no examination. It looks easy, it will be fast registered. It may be a mean for litigation. And I'm jumping to the bottom side. If you're thinking about German utility model, keep in mind you also run some risks because other companies may attack it. You may also go into a patent application in Germany without requesting for substantive examination, which would be about the same effect as a German utility model. So you have to select carefully. So I know we have less time I can talk about each of these aspects for about 50 minutes, but will not have the time. You have to focus and make decisions. That's probably the most important thing. And probably Germany as a sole selection, especially if you have not that much money available, will be a good goal.
Thank you, Christian. And now another view on that. This is Professor Godard's view, which probably may be different. And Heinz, again, you say me when I change the slide, when I need to change the slide. So it's your time.
Yeah, I should probably talk about, not on the left-hand side, you see, we don't have a unitary patent, not yet, it will come. We have heard all about this already. I would like to go to the right-hand side. 80% more actually, and there was 2018, the statistic of all patent litigation first instance in Europe at that time, even including still United Kingdom, are in Germany. It is not because the Germans are so litigious, but if you close by an injunctional decision the German market, you are closing practically 40%, a little bit less actually, of the whole European Union market against unauthorized use of your patent. So that means that certain companies, particularly, for example, in the semiconductor field and telecommunication field, which are very well known to me, but let's talk about semiconductors, never ever have filed a single European patent application. Even they say, if we have as a currency for buying freedom to operate for cross-licensing, if we have a German patent, that is enough threat to competitors with whom we negotiate to settle on a European basis, even based on a German decision. That means if you have the German patent, you negotiate with somebody who wishes, who could otherwise stop using of that patent in the European Union, and you stop him or that party owning that patent, that would not be possible for any serious competitor. You cannot leave out the German market, nearly 40% of the European Union market. So the German patent for currency purposes, for buying freedom to operate and granting freedom to operate, is as good as if you would have a European patent. And since that is so, looking at what Christian talked about, namely the cost comparison that you can get roughly, if you look at all the costs, official fees and attorneys' fees, translation costs, etc., that you can get about 3, as I would guess, German patents at the price of one so-called European patent, which is not really a European patent. It is this unfortunate creature which explodes practically at the time of grant and becomes, the fraction becomes national patents. Then you do a good job. And so it is a budget question at the end of the day. Tactics are different. What we observe in practice, and that might also be interesting for you in Russia, that more and more of our international clients, big clients, part of them, shift into the German filing procedures instead of the European ones, because they look at these budget considerations and say it is better to have a German, 3 German patents than 1 European patent. So the German litigation, and I said this literally triggers in 95% of all cases, and this is now a communication of the 10th Senate, the former chair thereof, of the German Federal Supreme Court. They observed this for a few years. Only in 5% of patent litigation which has taken place in Germany, there are parallel or following procedures out of parallel patents to that in other EU countries. That's it. That means in 95%, where the litigation has taken place or is taking place in Germany, that is the basis for a settlement of the whole patent dispute for the whole of Europe. This is the reason why. Thank you. Next slide, please. Yes, on the left-hand side, I don't wish to read this necessarily. Yes, and German patent courts, in German patent litigation courts, German national patents and German parts of EPC patents are similarly suitable. If you ask the former president of the German Federal Patent Court whether there is a statistic available how many patents are fully or partially invalidated in invalidation procedures, which are usually the natural consequence of filing a patent litigation suit in Germany, that the counterattack against the patent takes place at the end of the day at a German in patent invalidation court, like the Federal Patent Court, or later on at the Supreme Court. There are statistics available that they are not published, and they don't do this. The only thing I could get out of the former, at a conference in Washington, out of the former president of the German Federal Patent Court was distinctly more European patents are invalidated than national German patents. I did not check this myself. I don't know whether it is reliable information. It is more hearsaying, and that's only we can say. And this is what I have said on the right-hand side of this slide here. And in principle, yes, I would agree. I consider personally a German national patent as a stronger basis for a patent litigation in Germany than EPO patent, for the simple reason that it has a higher probability to survive either in its relevant part, still covering the infringing embodiments, or fully than European patents in German patent litigation. So German patents have a higher probability to survive. How much this is, I don't know, because the official statistics are not official statistics which would be published, but it is hearsay you hear here and there from judges in the Federal Supreme Court as well as in the German Federal Patent Court. Next, yeah, thank you. Yeah, this is a cost comparison, what it usually would cost to file at EPO, but this is more Christian's, I would say, what the support of what he said earlier already, what the total cost would be for a European patent that compared with the total cost for a German patent. And you will see this number. We have this total only on the left-hand side, 3,354,000 euro compared with the 11,279. This is that factor 3 where I said about if you put all costs together, and we have no time now to go through all the details here, you get for the price, for a certain price, three German patents compared with 1 European patent. Yeah. Next one. This is a different calculation again. We would need at least half an hour to discuss this calculation in detail. It only shows what we said earlier already, and Christian started with this general statement, namely that the German patents are distinctly cheaper to get than the European patents, so that if budget reasons play a role, and where don't budget reasons play a role, if you have a restricted budget, then you will get more patent protection because more patents available if you file nationally at the German Patent Office than at the European Patent Office. I am not advocating that one should file only European patent applications at the European Patent Office. Maybe a mixture is the best, that you prioritize your cases into normal cases, which you might wish to file at the EPO, at not so important cases you might wish to file at the GPTO, and at particularly important cases where you wish to file in parallel at the European Patent Office and the German Patent and Trademark Office. In the latter case, probably letting the case pending, Christian mentioned this already, without request for examination, wait for 7 years, look how all these patent litigation discussions concerning a future unified patent court will work, and then decide whether you prefer to have a national German patent at the end of the day. You file request for examination after 7 years. You get the patent then in 1 to 2 years thereafter, and then you are forever at the German patent court, patent courts. That means at the German patent litigation courts, and not at the UPC. And that might be something which certain parties might prefer. That's all for this slide. Is there another one?
Yeah, I think you partially described it, because
Exactly what I said. Yeah. Very
classification
important category A, important category B, not so important C. C in German Patent Office, category B in the EPO, with the option to opt out of the unitary patent, which in some case of my clients at least, we have blanket authority already to do so, or even instruction for all former patents, and sometimes 10,000 of them. And for very important applications, yes, my recommendation would be EPO application based on a machine translation, a cheap German application, just to keep it pending, to fulfill the absolutely necessary to be fulfilled requirements of translation at the German Patent Office in the cheapest way. And then after 7 years to decide whether you wish to go. Then with a new translation, you can replace the machine translation by a fresh application, a fresh translation thereafter without any problem. You can do this several times even. The only condition is that the first translation which you have filed, the machine translation, is a complete translation. but you can improve it. You can later on file new versions, etc. And I would do this always before going into examination, because then not only for the examiner, you wish to have a correct language under the control of a patent attorney, but particularly the language of the patent later on should be suitable for litigation purposes. And for that, I think a machine translation with all due respect to the machine translators nowadays, with up to 97% correctness, is not the basis, should not be the basis for a final patent grant. This would be my recommendation. Category A, both EPO and at cheapest cost at GPTO. Important at EPO because of the possibility later on to decide whether you wish the bundle patent with, that means in the end, national patents coming out of it in the designated countries, and in also unitary patent. And category C, not so important, if you wish so, only GPTO. So I mentioned again, in the special technology fields, I have clients which only file at GPTO, even the absolutely most important applications.
Great. So, great explanation. And let me ask you another frequent question, which is, I would say in frequency, almost similar to that one, when we can, enjoy the international patent. And this one, find what way is the best. Udo, may I ask you, because you reacted too naturally to that.
The typical answer, it depends. And it depends really on the circumstances you're talking about. It depends on industry, as Heinz might be different in PCT compared to chemistry. It depends on size of the company. What does it mean? We at BASF never thought really about the German market. It's always a European market, because the production plants are so big that the amount of product is sufficient for the entire market. We only looked at Europe, Asia, and the Americas, but not so much on Germany specifically. And budget, well, Heinz said budget is, it depends on budget. There's always a budget and it's always too small. So this is something in industry you will find everywhere. What you do with your budget, well, this is really up to you, and you have to convince your business that your choice is the best protection you can get for the money spent. And with all this, it boils down to, well, I can give you the example from chemistry. We are looking at the global market, and we decided in the 90s to move our priority applications to the European office. At that time, this was the only office really accepting electronic filing. The German office later came up with a similar way, but at that time, the EPO was the only one. So we moved, and the second argument was in a global IP community in a company, you better file in English. So everybody should be able to read your applications. Meanwhile, you can file in English in Germany too, but at that time, again, this was the best way to go to the European office. And in a big organization, you better have a standard way. So we kept filing at the European office, and in most cases, having PCT afterwards. Of course, this is more expensive than other ways, that's right. There are exceptions, but what we do not really want to see is that each and any attorney plays around with all the options available. This will be a mess in the end. We had 7 sites in Europe. When everyone decides to file the priority document at its home patent office, it's a lot of administration in the background to be done. This can be avoided when you move to the European office immediately. So with this, we had European office for priority, PCT in most cases, and yes, Christian is absolutely right, you buy time. But time is that's valuable. For example, you have an R&D project running and you come up with a lot of, let's say, new recommendations, improvements, and so on and so on. When you buy time of 2.5 years for the final decision, that's a lot. That's really helpful, because then you might know much better which is the final best product, best process for production. And you skip all the other ways. You may publish them, but you do not continue. And then you save a lot of money in the end, and you only continue with those applications which look promising for protecting the business. And overall, it's not that expensive, because you don't go, as Heinz rightfully said, into all the countries possible. You always focus on your business and your maybe production in certain countries.
Yeah, I just would like to add to Udo's comment. So I really completely agree with Udo's view on a thing from a perspective of the company. If you are, however, if you are an inventor, for example, an inventor in Russia, and you think about, well, there is a market in Germany for me, and it's only Germany, then I think you should really think, is it better to file it with the German Patent Office or with the European Patent Office? And if you have only the German market, I would recommend just to go to the German Patent Office. And this also depends a little bit on the technological field where you're working. So, for example, if you have inventions or products in the automotive field, I think one of the best ways to protect your invention is the German Patent Office, because all the cars move around whole Europe. So you have one perfect country for this. If you think about, for example, wind power plants built in Spain, is established in Spain and built in Netherlands and established in Netherlands, then you need in all these different countries a patent, so the thing is completely different.
Thank you. We move to another slide, which is about patent services offered in Germany, because we anyway have to select a patent practitioner to act before any of the offices, either one. And here I have three questions. I knew in advance that Heinz will be leaving for a meeting. So those three questions are each aimed at each of you. The first one is Christian's. Representation services before the EPO, who offer them? The second one is German patent firms. Are they all similar? I wanted to devote that question to Dr. Edgar Dussel. And the third one, how to estimate the quality and reasonability of the services? This is Dr. Meyer's question. So with that, we start. Christian, who offer representation services before the EPO?
Yeah, thank you, Yuri. So who offers them? Actually, you have to be what we call a European patent attorney. Luckily, I don't have to say the German term. It's quite long. So anybody who has been qualified to represent before the EPO, yeah, that's a 3 to 4 year trainingship with examination at the end. You're entitled to represent somebody else at the European Patent Office. As company, in principle, you can do it by your own employees. When you're sitting in Europe, then you don't have to do that. Otherwise, it's European patent attorneys, yeah, like for example myself, and they are sitting all over Europe. Yeah, we have to say that. But frankly, if you look into the numbers, I think the majority of representations and firms are located, I think, in number one in Germany and secondly in UK. And in UK with a strongly connection to United States. So the Anglo-Saxon cooperation is there quite strongly, and Germany is relatively strong because EPO and EPC is kind of modeled from the German system. So they are naturally close. It's a very comparable system. Of course, the European Patent Office with its home base is in Munich, so also based in Germany. So we'll have a strong focus on Germany when you're talking about EPC. And secondly, just my recommendation is it's good to have people, especially in those jurisdictions, being familiar with the language and being very familiar with the with the procedures, and I don't want to go into detail with that, but you know, representatives from certain countries, you have them on the other side. This is from our experience. There you notice the experience or the lack of experience. So qualification is the one, and experience and knowledge is the second one. That also comes then probably to topic 2. I want to say anything about that, but carefully look for somebody whom you trust in your representation. And that is not only the formal signature, but it's, you have to have a person, probably I think you're quite confused after this hour, confused, but on a higher level. So you need somebody whom you trust, and to give you a good advice where to go when he's listening to you, what your intentions and your business goals is. And if he understands this, he translates it to you and then says, well, look, this is the best way to proceed, because otherwise you will not see a light at the end of the tunnel. So look for them who understand you, your business, and give you reasonable advice. And there's, as Yuri has said, and as Udo has said, there's not the one solution. And if I talk about my clients, well, is there risk here? Is there risk there? I ask my clients, well, look, don't ask an attorney, is there a risk or is there the best way? Ask the attorney, if you would be in my position, what would you do? And then we can give a good advice without bothering you with all the details you have just heard on the scratch. You need somebody to guide you through the very complex system which there is in Europe.
Thank you, Christian. And Dr. Dussel, are German patent firms are all similar, or do they differ in something?
Yeah, well, I think that's an interesting question, and I will answer this as I'm heading the IP department of a company. I would answer this question from this perspective. So Schaeffler has more than 10,000 products, and this is the main thing, how we look at the patent law firms in Germany. So the first difference between the law firms in Germany, of course, is experience in different technologies. Do they have experience in wind power plants or in bearings? Do they have experience in some car, some products in a car or something like that? So I would say, well, to answer this, no, with respect to technology. So there are many specialists in different fields of technologies. So you carefully should find out, is the law firm really experienced in these technologies? But there may be also a difference in well, what is the main working field of this law firm? Are they mainly doing patent drafting, examination procedures, or is there a lot of experience in oppositions and that field? And as we typically have much less oppositions than drafting patent applications or applications per year, so there is of course a difference between that. And then you also may think, well, what is the size of this law firm? So if you have a bigger size of the law firm, you have probably more technological directions and more interactions between the attorneys. So this is also something. But the most difference which we see is litigation and experience in license negotiations. So there are, of course, different level of knowledges available. On the other end, I would say, well, all the German patent law firms may provide you with a substantial and validated advice. We cannot hear you.
I'm sorry, Dr. Meyer, this is your time to share with us. How do you estimate the quality and reasonability of services you received from the patent firms?
When you have a nice definition of quality of a patent application, well, this is something, then you know how to check it. And if you really know how to check it, you can give, you can open up a service company giving advice to all the IP departments in Germany. It's not there, quite frankly. I mean, the final proof of quality is litigation. does the patent hold or is it revoked? But only a very, very few patents make it to litigation. So this is not something you can really use. What we try to do when we check quality of a law firm when it comes to patent applications is mainly the formalities. Did you get a timely response? Has the outside attorney covered all aspects of the invention? Has he really incorporated all the input he got from the IP department? But these are, as I said, formalities. Does it really touch the core of the patent? I'm not sure. This is really difficult to judge in the end. It's a lot of gut feeling. So we, in most cases, decided to build on long-standing relationship to certain law firms where you really know, yes, they always tried and will continue to try to have high quality, whatever it is, what you see from their questions, how they know your own business, your patent portfolio, this is helpful. And reasonability of services, well, this might be even more difficult. You can try to get the cheapest application available, but this is cheap in the end. It's not only inexpensive, it's cheap because the attorney will not spend too much time on it and not think about it. This is not the best way to go. So you have to find a price level, I think, which allows a win-win situation. You, as a company, wouldn't like to pay too much, but on the other hand, the law firm has to make profit out of it. And if you have a rather large portfolio, as we have, and you can make sure that a certain law firm receives a certain number of cases per year, you can try, as we did, to fix a fixed price for a patent application, not depending on the hours spent on each and any application, but on average, it costs like this. There might be exceptions, but this should be only a very few. So what we did over the years, we developed our own fee schedule. We did not accept the fee schedules of the companies anymore. We negotiated and said, well, this is what we are going to pay. And we know there are some applications where you might spend less time than average, and there are others where you spend more. And with this, we hope that we could find a reasonable price for the services received. But as I said, this needs experience. It needs a lot of discussion with the law firms because you don't want to be the client who is last when it comes to difficult work, and the attorney says, well, no, we can do this later. This is just BASF. I'm not going to deal with this as long as I have other cases on my table.
Thank you very much, Dr. Meyer. We are at the end of our first roundtable, and we already received a question regarding the most effective allocation of functions between local and outsourcing law services. Good question, but it will be well addressed in our second roundtable. And I think that means this question signifies that it's a good sign. It signifies that we finished our warming up, and that was warming up in good shape. And we're now ready to move to another topic, which is, I think, one of the most important now. And this is about the in-house services. Just a second. Here. And I am going to share it with you. And to start it, yes, I have an assistance from our computer department. here. So we move to our second roundtable immediately. Forgive me for that rush, but we have many questions to discuss. And this roundtable is devoted to the patent departments in German scientific and industrial companies, their interaction with outside consoles. Again, let me refresh the rules on the rules of our roundtables, these and other ones. We welcome questions and comments, although they are to be aligned with what we discuss. We reserve approximately 10 minutes to finalize. Please write your questions in the chat. We will be certainly answering them. Disclaimer is similar. Again, do not consider something that we discussed right now. And even very good example that we prepared for you of how IP service is working in Schaeffler company. Do not recognize them as immediate advice how to do that for you in-house, although it may well fit for you, but think over that. Basing on what we have to discuss and what we will be discussing right now. Here I need to introduce the definition of the terms, which is quite important. We use throughout the whole our presentation, we will use two terms to define various people. The first one is in-house console, or just in-house, for simplifying that. We denote by this meaning a person who is an employee, and which is a critical matter, of a non-legal practicing company and who works with the own IP of that company, or probably somehow associated with that company, created by employees or by contracted persons. Outside counsel is a person who is an individual IP practitioner or an employee of a law firm working with not own IP matters. With all that, we start to discuss what is a modern in-house patent trademark practice looks like. And let me introduce some historical matters here, although they are well known. I'm pretty sure for many of you that historically I read many books on that, and historically most researchers agree that the first true in-house service appeared and was established in the Westinghouse, in one of the Westinghouse companies around years 1886, 1888. Before that, Westinghouse, being a classical technological developing company, was continuously using almost one and the same law firm. And at the time, George Westinghouse was thinking about buying the patents from Nikola Tesla for their evaluation, including the quality the applications were written and the procedure with the patent office was conducted. He hired his main outside patent lawyer to become the in-house practitioner and establish that in-house practice. Many years afterwards, that gentleman left Westinghouse, but the in-house department of Westinghouse company hadn't ended with his leave. It continues successful work, and is still working, being one of the world largest IP in-house IP practices. Since that, we see a growth of in-house practices, which now are numerous. They are working in many companies, and not only manufacturing companies, but also in educational institutions and universities. Let me say they all are effective, or at least they think they are effective. They all are valuable for their companies. And well, to my knowledge, no one exactly is the same as another one. So they all are different, but still remaining effective and valuable. One sociological survey conducted somewhat like 15 years ago in Silicon Valley, where lots of IP-based companies are located. The purpose of that such a sociological survey was to question the companies to various topics, including IP. And the question was probably aimed to receive another answer that it did. The question was, who is the main generator of IP in your company? And around 75% of the respondents answered our IP service. And I think that was a very good reality and very valuable estimation of what IP in-house practitioners do. Some more history. Over 50 years ago in USSR, exactly in year 1967, the Soviet government issued statute on measures for improving patent and licensing work. It is a very interesting document, and I think it hasn't lost its actuality on today. It required that all enterprises shall have in-house patent departments with staff completed by highly competent specialists. And it was written there that in-house patent departments shall provide full information support to R&D tasks, conduct technical examination of newly created solutions, prepare patent applications for filing in the USSR and abroad, conduct FTOs abroad and prepare proposals for licensing out, study foreign solutions and prepare proposals for their licensing in. Very interesting document. Let me repeat that, it is still actual. And with that, let me ask you, as leading German practitioners, all of you were and are connected with in-house practice. Do you know about any governmental regulations, recommendations, or whatever available in Europe and in Germany on in-house IP services, how to establish the system, how to develop it, what it should be done by that in-house IP department or service, whatever. Dr. Meyer, may I ask you to start?
Du bist noch muted, Udo.
Sorry, I'm not aware of governmental regulations on in-house counsel functions. For example, you can outsource your entire IP service to a law firm, so you're not obliged to have an internal service or a certain setup for those questions. The only thing I'm aware of is a relatively new standard on IP management by the German Standardization Institute. But this does not help you to really set up the organization. It just gives recommendations what you should consider when you're doing your IP work. But this is not a real, it's not a tough regulation you have to observe.
Yeah, I completely can confirm this. So at least from a perspective of a governmental regulation, so there are no regulations forcing any company into some behavior. So you're completely free to choose to do everything completely in-house, to do everything completely externally. So you're completely free as you think how it fits to your expected business. So to come from a company side, it's more or less a question of how can we provide an optimum of service with a given budget, and that's where you have to make the decisions. So no, but with perspective of regulation, so there are no regulations.
Christian, you as a member of many professional associations, do they recommend anything?
No, I think that's completed there, neither from government nor from the professional associations. They give recommendations out according to my knowledge. And I think there's a good reason for it, because the situation is very different depending on the company and the needs.
That's another sign that we can establish whatever we think effective.
No, really, I think point is it too much depends on the specific situation. And let's start probably from what I've seen from all the in-house institutions I have been. I've mentioned 3 of them. Just the one I was building up when I was there was nothing at the beginning, so I started to build it up because they went into intellectual property with about 400 researchers and a lot of development. So they needed actually something there. They had 400 people, researchers, doing nothing else than inventing something, and they had no IP department. The second one was a medium-sized department with about 30, 35 people, and the last one, Sony, you can imagine, with a couple of hundred people working into IP, but in a very different structure. I think recommendation for most of the participants, I assume you don't have an internal patent department, and that would be quite natural. You start with invention. So first thing is find somebody who is responsible to collect that, to bring the strings together, to tell people that there are patents, to gather the information. So have a person there kind of trying to bring everybody on speed to think about that there is a patent system and a protection system. Yeah, and that person will probably then need support from outside. And as the work develops, yeah, there may be a first start for needing and say, well, look, yeah, I have so much work to do. I can fully cover that with a person doing nothing else than IP in your company. That's probably the starting core for your in-house patent department. And then you develop. Let's phrase it this way: if you have not a full person being experienced and can handle this, you are, yeah, necessarily you have to work with outside advisors going deep into your company. And that's also our work, very different. If I work with small and medium-sized enterprises, I'm sitting together with them, I'm explaining the situation, I'm part of development actually, and saying, yeah, they want to have a product developed which can be protected. We're sitting together and changing the product together, because I say, well, this you can probably protect, there's not that much there, you have a problem with other patents, etc. So it's kind of a developing process, yeah, starting probably with a person. You always have somebody, yeah, feeling responsible for IP, and then you have some person to, yeah, only do IP and work with external departments, and then you may grow, yeah, step by step depending on your activities. I think this is a way of development. And then if you of course end up with companies, yeah, Edgar and Udo are responsible, therefore of course you have a huge patent department, but even there the tasks are very different. So yeah, I mean, probably Edgar or Udo, you may say something. You may draft patent applications in-house. In Japan they do not, so even
good
there,
occasion to
tasks
say
are
to
different.
discuss this slide, what is usually done in-house.
Yeah, I can add here something. So I think all the IP departments in Germany of companies are different in their scope, what they do. So, and what you mainly have to meet is the requirement of your board. So if the board says, well, what is the value contribution of the IP department? And you can answer this, well, on the one hand, we are doing, we are doing kind of a repel activity where I mean, well, to make sure that we do not bring products on the market which might infringe any third party's patent, or to think about, well, what can we do against these patents? And the next thing is to protect our own inventions, which are made in order to bring us into a position which is of some value for the markets we are active. And the third might be, so something like, if you, especially what we today see is a complete technological change in the field of automotive, for example. And there a lot of demand comes up, like, well, information, as you mentioned here above, information searches, but not only information search, but they need some kind of technological overview. What technologies have already been some other companies working on? Who are the main players? What is their scope of protection? And just to have this as a basis, and this is becoming more and more important.
Mr. Meyer?
Yeah, maybe I can add to that. As Christian said, the situation in the SMEs, this is exactly what you described with the Westinghouse example, or what I know from BASF in 1890s. The core of the patent department was connecting external attorneys and the inventors. And this is how it starts, and then it kind of develops, because you see over time, well, maybe working 100% externally is too expensive. Maybe we can do something internally, which might be faster and less expensive, and so on and so on. You develop capabilities over time, and this is how a department grows. And what, when I look at your list, well, that's all true. Nothing probably to 100% in-house, because you split it and say, well, very specific tasks should be dealt with by an external specialist, because you don't have the technical knowledge or the capabilities internally. Other things are too sensitive. Maybe many companies decide to do licensing internally, because this is really connecting the business interests and then negotiating with the partner. Another example, information searches. Well, these are, of course, searches done before you file a patent, just to see whether your own invention is novelty or not. But there is much more in it. There are specialized companies out there, as Edgar said, where you can get a check of the portfolio of your competitors, where you even can look for interesting targets for acquisition, which hold a certain portfolio which really fits into your own business interests perfectly, so that you might consider to either buy the IP, or maybe in a huge organization, even the entire company. So there are broader aspects today than in the past. And that's why you need, and we will talk about the persons involved in the department later, you do not only need the good attorneys really knowing how to apply and to get a grant of patent. You need those understanding the business and seeing what can I do with the IP, and which IP do I need, and how can I support my business with this.
Fine. And variation of in-house work. Although we slightly touched that topic, but does the structure or the tasks of in-house work, in-house patent service depend on specific field of art, scientific or manufacturing nature of in-house employer, or whatever else? Whatever else does it depend from? Christian, maybe you again start.
Yeah, I think of course the kind of business you're in also has a major influence on what you're doing in IP. Let's go through your area, scientific or manufacturing nature. If you're more on the scientific and research area, then naturally you will have more innovation and therefore probably more patents. If you're on the manufacturing side, yeah, you're probably not developing new products that many, so it's a different kind. But also in manufacturing, keep in mind that you of course has further developments, and you may manufacture easier, more cheaper, etc. So also there you need some input on that, but probably the number of applications may be lesser, and also there you need probably a good connection to an outside attorney, because especially if you're talking about just manufacturing methods, etc., you may not want to file a patent application because you give too much information outside. So also this is something which is coming from the outside, where you need a specific attorney. branch of technology, also same thing. I mean, it's a very different area when you're working on ITC, that means telecommunication, where you have hundreds and thousands of patents, or you're working more in technological area, that means real technology, not software or soft technology or computer implemented inventions, or even in chemistry, and you have a very different approach to that. And that means different tasks, different ways of protection, therefore also different situations and what you can do internally and what you can do externally. So yes, the in-house work remarkably deviates from your tasks, from your goals, and how you accomplish that. And I think, again, the important thing is, if you don't have a settled one like Edgar and Udo have, but which was also not prepared on scratch, it was not just there, it developed over decades until it is kind of best practices in two very different areas. And if you would compare Edgar's and Udo's department, you will also see a lot of differences, just because of the difference of technology. So but start stepwise and build up internal knowledge, because that's probably an important thing. In-house patent departments have to have in-house knowledge, and they have to develop that. And at the beginning, they develop it with external attorneys.
Exactly, very good topic. And it exactly goes to our next slide, which is, you already uncovered to us, Christian, some part of your biography. So what is the first step in establishing in-house practice in a corporation? You start, and then Edgar and Udo add their stories.
Okay, I can probably talk about from the one experience I had, where we had a situation, as mentioned, we had 400 researchers just on one location gathered from all over the world, and money in abundance for research. So a very unusual situation, a good situation for all the researchers. Is why they love to work there, and a lot of innovations, but nobody collecting that. So I think the first step is really like acknowledging and internally spreading the information that there is not only research and good products and good results, what the researchers can do very well, but that you also have to protect it somehow. I think that's the first thing. So creating of awareness, and that were really my first task also under the researchers, like saying, look, you're doing good job, but if you want to have a business case out of that for your company, for you're working for, you have to keep the business in mind, and business means patents. Think about that. And then it probably starts also on a department where I said somebody running around spreading the information, collecting information, understanding what the competitors are doing. So probably on your slide you had at the beginning, information searches, analysis, monitoring, etc. These were the first steps. Frankly, if we're going to other topics like patent application drafting, I've mentioned at the beginning, your first draft should be good. And if you don't have that experience, don't trust it anybody in-house. I mean, you can hire, of course, an attorney who is experienced. That may be one thing, but probably if you do not have too many applications, that would be something you do out first, and then you gather that information. So it's really stepwise, and it certainly comes from the one side on the R&D department or the research department. On the second side, on understanding what your business is going to do. And then you connect people. So actually, really, I think the starting IP practices, you connect R&D development with business on the one hand and legal on the other hand. And legal means that you know how to best work. And then you stepwise go better, you gather your own experience, you can take in more tasks, because first you know what to do. That's important. And secondly, as Udo has mentioned, after a while, it's also economically good to have a person in-house doing only these things. And there you go, stepwise forward. And don't expect that this is done within 1 or 2 years. That's a longer time period. That was also, I had to explain them, well, they started with nothing, and they said, well, best practice BASF, or I don't know which, I want to have that. I say, yeah, you can have that, but you won't have that in the next 5 years, actually, because also they needed 30 years until that step. So it's a long task, but it's rewardable, and go stepwise forward. So start developing it, not putting it just in place, and then you're on a good way.
So Dr. Meyer, you respond.
Yes, it's not only a first step; it's a continuous step, no? Because you have to adapt all the changes the company has over time. For example, there might be new technologies. You have to have experts in the new fields. You stop certain technologies. So this is something. What are you going to do with your old patent portfolio? Then you have globalization. This means you might have attorneys at different sites outside your home country. How do you build up a department covering all aspects, but still keeping some processes in common? You need a database today, of course, and so on and so on. So this is there is not an end to it. You start, as Christian rightfully described, with connecting, and this will stay one of the main tasks: connecting R&D, business interests, and so on. This will never change, but the content might develop over time.
Yeah, I can add a little bit. So, what is the first step in establishing? From our experience, we normally saw that when a company grows in the area of R&D, you normally always find one person having some interest in technology and in law. So this person is an ideal man or ideal woman for that job. So to be present, but this person should also get the allowance, should be allowed to take care for all these issues, to establish some kind of processes, how to collect the inventions internally. And I think one very important and very difficult to handle process for an external law firm is to evaluate the value of the invention which was made. So you normally need someone in-house in order to evaluate, well, is it worthwhile or not? Is it already known, to do the first searches? And I think if we talk about the first step, then this is the first step, and further steps may develop. And of course, it's of a big value for a company if the company finds someone in this person who has some experience in processes, how to handle this, who has to be asked for, who can do the searches, and to bring it all together.
Thank you, Edgar. And of course, any service is based on people. So where can we find new analysis? Or just the first ones? So Edgar, probably you start.
Yeah, that's now we talk about in Germany about the so-called Facharbeitermangel. So there are only few experts on the market available. So that we can clearly say this. Even if you look at the well-educated patent attorneys and the patent attorneys working in companies. Of course, you find some new talents when they have finalized their education at the universities and doing the first steps at a law firm or within a company. But I think Christian as well as Udo can confirm it takes something about 2 to 3 years until someone is really comfortable, new in the IP field, and has understood what are the processes, why do we have all these processes, what is the safety. We have been talking about quality, how can you ensure that within a company. So if you say, well, if you want to look for someone who is the best for this company, you have to look for someone having been working in-house. If you're looking for a company in-house, at least I would say 3 years, and then it should be something which is quite small, and this person should have a network to really recognize what is done in the industry.
Udo?
We tried all the ways the own employees, yes, but this takes time, as you heard, and you have to have an attorney who is really good in education or in training your own people. But what you get are really, from my experience, are people really knowing their job, because they usually started in R&D. They know the company, they know the processes, and then they learn the IP part of it, which makes them really valuable attorneys, in the sense that they do not have problems starting, how to connect people, how to discuss what to do in detail. But as I said, it takes too much time. Known outside counsels, yes, but we see they tend more than the internals to leave the company after a couple of years, which is always, well, something you regret. Then in-house people from other companies, well, no, we are not stealing attorneys from other companies, because those companies would respond in the same way. It doesn't make sense. When people apply on their own and say, well, I would like to leave, blah, 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 do you have a nice position? This is something different, but actively, we do not go into other companies. There are not sufficient attorneys around, so you shouldn't start this process. Patent examiners, only from time to time, quite frankly, they are not sufficiently broad in the aspects of IP. They know patent applications perfectly, but that's it, and only a very few really open up after a couple of years in the offices. People tend to slow down a little bit. Recruiting agencies, definitely. This is something you have to do. But nonetheless, when there is no market, they have problems finding suitable candidates. So it's an unsolved, big, serious problem. And when you currently look for someone experienced in-house attorney in digitalization, well, it's frustrating. Nobody around.
Christian, and your thoughts on that?
Only few in addition. I can fully follow what Edgar and especially Udo has said. I mean, actually, I was working in a couple of in-house departments, but I was never recruiting on in that part, but building up, and we're looking actually in the one thing for in-house people. So that's the one thing I did. Otherwise, I can fully follow Udo. Same situation, by the way, for law firms. I mean, also we are looking for future people. And it depends. So what I would probably emphasize is patent examiners is, yeah, they know how to examine, but they don't even know how to draft a patent application. We see that quite frequently. And then they don't know the strategic and business approach, and they don't know the company's approach. So patent examiners, yes, you can do so, but also for them, it takes a while until they see the needs of the company, which is business, and not, yes, that's fine and that's not fine, and just following the patent law, but well, of course they have their background. And allow me one thing, I just see the question here, which is probably related there to, if we have an internal patent department, whom should they be connected to? And that's probably close to, no, not to marketing actually. That's the wrong thing. So keep IP and patents in that area close to R&D. That was the one question. And that was also what I heard from Udo. When they have internal people, they recruit them from R&D, not from legal, because core point what you're dealing with is technology. So look for R&D people, and yeah, if you're hiring from there, look first for people who understand technology. Otherwise, they are lost. Internally, if they know the technology and if they are close connected, then probably the best way to do what you can get.
So can you, Christian, can you immediately complete this phrase as if it is from the vacancy? A successful candidate shall demonstrate excellent knowledge of
the technology involved and the needs of the company.
And everybody agree.
Even more, and communication skills. It
Yeah.
does make sense when you're the,
About that a bit.
but you cannot talk to the business people and translate it, and you can't explain what it means. So you need someone who, on the one hand, has to be kind of an introvert, really studying deeply in technology and in the legal domain. On the other hand, an extrovert really being able to simplify and to discuss those matters, which is close to impossible, but that would be the ideal candidate.
Yeah, and I only would add, so what we think is important to our ideal candidates, they need a certain thinking of, well, thinking a little bit broader, so to broaden the scope of the invention. So they have one invention which was made, and then say, okay, what is the basic idea behind that, and how can I kind of broaden this in my claims?
Probably a short addition, because Udo has mentioned the translator. I think that's a good thing. I always explain our work as translator. And the one is translating the technology into a patent claim. And when you're not involved in patents, and if you probably have ever read claim number 1, the first claim which should protect your invention, and you are the inventor and you have never read something, probably you don't understand what claim 1 means. So, and that's already an issue. So you translate technology into patent language. And the second thing is also right. Then you go to the outside, to the business part, and then you have to communicate and translate what you're doing there to your management, that they see, yes, there's reason to do that. And probably the important thing is, Udo has also mentioned, checking quality, the results, it's not short-term. So also keep that in mind. So if you start it, you will not see the result next years. So it's a medium and long-term investment. And also this has to be communicated internally, because you don't see the result in your next quarterly report, only probably by more costs. But that is something you have to invest in that.
So, gentlemen, so many attractive opportunities around you, and why it is good to become an in-house counsel?
Well, I can start with that. So, so if the question is, well, to become a patent attorney in a law firm or to become a good in-house counsel, there is one. It depends a little bit on what the candidate really wants. So, the big advantage in a company is that over the years you have so many opportunities to come in contact with different technologies, with different products, with the whole area of intellectual property, like oppositions, like litigation, like licensing. So you have the full, complete scope, and you have also a kind of a feeling to support a business unit, bringing more value to the business. So, and you have this direct contact instead of an outside law firm.
I started in R&D, and after a while I felt, well, that is not satisfying for the next 30 years. I moved into the IP department, and this was kind of an intellectual challenge in the beginning to work in this new field, legal environment, all the clauses in contracts and so on and so on. And then you can really feel that you can do something good for the business in the end, because when you're negotiating a license, this is quite clear. You're really doing everything for your employer. This is a kind of competition with the other side, of course, but this is something where you can move something as an expert in the organization, and it is a very special field, so there are not too many around really knowing better what you do. It stays interesting for years.
Yeah, and probably last addition from my side, although everybody sees I've gone into private practice, but we all have a technological or natural science background. So if you decide to go to IP, you have 3 choices. The one is you go into private practice. The second one is you go into in-house patent department, or the third one is to become a patent examiner. Actually, I'd normally say either you want to become a patent examiner, because it's a very different work, and this is why it's probably not suited for company, neither for company nor for in-house counsel, or you're on the other side. And here I would say, well, both of them has a lot of advantages. And you see, I went into private practice, but I'm still missing a little bit. Like say, why why am I not for longer years actually in an in-house department? And I think the in-house counsel has the advantage that you're closer connected to just one company. You have a deeper penetration, not only the patent, but the business behind that, going down to the very product. Yeah, so you have the whole range of one product. For me as a patent attorney in private practice, of course, yeah, for large companies, probably I get a certain task. I just get a puzzle from a big structure and I see this one. For my SMEs, I'm closer there. As I mentioned, if I consult SMEs, I'm closer to an internal in-house counsel because I'm doing more. But that is, I think, the nice thing in an in-house department. You see the whole structure from top to beginning, from development to the final product in each of the countries. Yeah, that's also, I mean, I'm a German European patent attorney. I see partly what's happening in the United States, but you have the whole picture in an in-house counsel department, and that's, I think, that is tempting, and that's, yeah, a really nice job.
Thank you. And now we go to more detailed questions regarding allocation of loads and cooperation. So cooperation, is it needed? Or do in-houses really need outsides?
It's absolutely needed, and it's not being opponents, it's being partners. You need the specific knowledge, you need the work capacity in some cases because you can't deal with all the cases internally, and you have to have a good working relationship, and you have to trust your partner that he or she will be in the position to really fulfill your requirements at a high level. So there is no doubt that you need outsides again and again.
Allocation of loads, a very tough question, and we will try to come to its understanding by various ways. So taking it from various sides, from straightforward, from backward, left and right. And the first, our straightforward questions. Should financial optimization be the main criterion that motivates changes in dispatching works to and from? Let's start with it. Maybe.
Yeah, if we're going to start with this, I would say no as the main criteria. I would not say no, the main criteria. It's also when I was in the United States one time, so one of the patent attorneys said to me, well, you get what you pay for in the end. So, and this to a certain extent shows what's behind it is. So to have really criteria on board which bring you in a position to make a decision for the benefit of the company. You cannot, well, to be honest, you cannot say, well, this technology, for example, is of some kind of minor importance, so I would give it to someone, maybe an outside law firm or internally, and just do not treat it as a kind of a valuable patent. If you come to this decision, is much better to say, well, I do not file for a patent anyhow. So I would not say the main criteria is the financial optimization. It's also very important to have a close relationship in all the stages where you work with external counsels.
Internally, you are pushed more and more into financial optimization of your department. Of course, you get budget restrictions again and again, and in the end you ask yourself, how can I really come up with this? But I would agree to what Edgar said. It's not the main criterion to get the work done as inexpensive as possible. A couple of years ago, I saw a German company starting a bidding process for 10 patent applications. So you can bid as a law firm, say, this is my price, and the cheapest offer wins. I mean, this is really, what you pay for. And if you don't pay that much, you get a lousy quality. This does not work, I think. On the other hand, I already mentioned long-standing relationship and trust in the quality of your partner. These are soft factors. And when you talk to the financial managers in your company, this is hard to defend, that you pay a little bit more than you could pay when you really go to for the cheapest offer. But nonetheless, I think this is something you have to do, and you have to convince people. Otherwise, your portfolio will go down in quality within a couple of years, I'm sure.
Yeah, and probably a short part from my side, I can only fully agree what Edgar and Udo have said. So you should start with optimization. That's the first point. Let the people who are best suited do their job. If you have a good person in-house and being qualified to do that specific work, and you've seen already, there's a lot of work like doing searches, drafting patent applications, talking about licensing, talking about negotiations, etc. So you will find a person being most suitable for the job, and that may be partly in-house and maybe partly externally. And this optimization at the very end leads also to a reasonable or the best financial result. If the work is done by a person who does not know what to do, they need a longer time, and then internally as externally, it's getting more time and therefore higher expenses. And even worse, if they do something wrong at that time, it costs 3 or 4 times the same money to repair that. That starts with patent applications and draftings. If they are wrong, drafting a lousy patent application, you probably have thrown the money out of the window anyway. And if you try to repair it, it costs much more at a second step. If you do the errors in negotiations, you're losing money right away. So think about optimization, although of course money, I know for everybody money is an issue, so you cannot waste money, but think about the tasks and optimization there, and then financial comes second.
Okay, I agree with optimization, but let me try filling the margins of that optimization, the minimal and maximum margins. So let's start with maximum ones. Assuming you have unlimited budget, you are so loved by the management that they say spend whatever you want and how much ever you want. Then, will you hire in-house counsels to cover all your current tasks? All probably no. So
I would say probably no. So first of all, during the long-lasting experience within a company, things may change very rapidly. So you have a very nice year this year, and you may have a very difficult year next year. So you never don't know. And to have everything in-house is a kind of a burden which really cuts off a certain flexibility. And on the second thing is, what we recognize at the moment is that presently a lot of changes are going on. I just talk about this very colorful expression, artificial intelligence, supporting somehow the searches which can be done. And it's quite very easy that there might come up in the near future some companies which can do searches much better. So I would not completely do that.
Yeah, I agree. You better focus on the relevant tasks, not all current tasks. Doesn't make sense. There will be always very specific technical questions, for example, where you don't need an expert internally because you have the question once in a year. So you better turn to someone in a law firm who will do this quite easily, and you don't have all the costs over the entire year on your budget.
Okay, let's go to the minimal margin. Although, Christian, if you want to contribute to the maximum, you're also welcome. So let's look at minimal margin. You have very limited budget. Whom you would prefer to hire as minimal specialists, minimal number of specialists in IP work for your in-house department?
I can give you a number, but I would prioritize the business units really relevant for IP. For example, pharmaceuticals or pesticides or things like this, where you really have a very close relationship between patent protection, pricing, and financial success in the market. And I would cover as much of those interesting business units as possible with my limited budget, and all the rest could be done externally.
Yeah.
Yes, Edgar.
One also could add, saying, okay, what are the most important objects within a company? So if you say, well, finding out the inventions, talking to the inventor, making the invention clear, and having someone who is capable of communicating with an external law firm in the sense, as we had already been discussing before, in the sense of, well, translation. So you have the inventor, very technically knowledgeable, then you have the application which shall be drafted out of this invention, and this has to be done by the external law firm. So I think from a perspective of minimum, I would try to cover something about 80% of the technologies with in-house knowledge, with an in-house IP specialist, and then try to build up some knowledge of drafting, but not necessarily in the very beginning, depending a little bit on the size of the company.
We have talked already about the translation issues, or we can call it translation issues or communication issues or interfaces. So we start at the one end, which is the R&D. Somebody has to make the invention, and probably at the very end, on the other side, we end up with a patent application or the patent to be granted. And there are many steps in between. And if I'm starting, and if I'm talking about minimum in-house, then I would take those parts in-house which are close to the company. And close to the company is the R&D and the further developing and the harvesting then, and then going from there to the next step. And there you can communicate already outside. But if you go from the other side, like the communication with the patent office, possibly even litigation, etc., this is something an external patent department or an external patent attorney can do. But yeah, if you start especially with that, even if it's a good patent attorney, say, well, look, here's my company. He probably needs a year to understand really the internals of your companies. So in that whole broad range you have, like, from the invention up to the final patent, the invention, the structure internally, the harvesting of the invention, this is close to the company. So I would start there. And the further I go away in the steps, like maybe time-wise, or to the IP or to the communication with the patent attorneys, then I would entrust that to external departments. But the connection, the flow of the interfaces have to be as good as possible to have a good system. And then you have to start at your part on the patent, on your company, and then you grow together probably with the externals. So you have to start at your part. That means the starting point, harvesting information internally, R&D, and take somebody who is close to R&D and not to marketing and not to legal.
Thank you, Christian. Gentlemen, tell us honestly what you will never allow to do outside being heads of in-house services. Anyone ready to answer?
I've quickly slipped through that, and there is one from it's based on my experience. The services calculating the inventors remuneration, I would try to have it as much as possible inside. Mainly probably because of the German compensation system. It's strongly connected to internal figures, to sales figures, and to all that stuff. And it's also much easier to also deal with the inventors in this field. So that's from a first slipping through this.
Okay. Udo?
Yeah, same with me. I mean, I was responsible for service inventions and the remuneration for a couple of years. And when you look at all the sales figures, you would have to to hand out to the external attorney so that he can do the calculations, and then you get the results and you have to make the payment internally anyway, there is no real benefit. You move a lot of paper or data today around, and this is number one. I wouldn't allow to be done externally. And number two is litigation. Due to a lack of experience in chemicals, you have litigation only from time to time. You do not have real internal experienced attorneys in the field. So what you can do is you work with the externals. You have the attorney responsible internally, knowing the cases, the environment, the business, and so on. And he's discussing, providing data and all the things to an external, but this would be number two on my list, not to be done outside. Outside.
Okay, Christian.
Yeah, I agree. So especially remuneration negotiations with inventors. So following up what I've just said, that's very close to the company. If you negotiate with the inventors, you always have the discussion who was an inventor and who was not. And as an external, you simply have no idea actually. Yeah, you have to know your people. You have to know what was behind that development and who really contributed or who just worked on the machine and was doing what was said to him. I think that's the one point. And I think if I understood you, Udo, correctly, on the other side is litigation. There you need somebody externally because you don't have that much. That also reflects, for example, if I see developments over SMEs, for example, I have really two SMEs I was working with for them for 20 years. The first thing which started with, I had one contact person. Yeah, and then he was working with me over many years. And ultimately, and that's a good development actually, ultimately he became a European patent attorney. So now, yeah, I've lost some work. That's absolutely fine. But that was very rewarding for me as well, because I saw the development and we still have close connections. And no, he's not contacting me for patent drafting because he does that by himself. But if it goes to opposition, if it goes to litigation, he's still there with me and we're still discussing. So it's a very beautiful development. And probably one thing I also want to mention is if I see here negotiations with parties, that could be on different parts. So it could be in patent litigation, it could be in licensing. Yes, attorneys can do so as well external, but external attorneys are in dispute. They will never say anything, even if it is reasonable, which would be against their party. They want to fight. So sometimes it's good if you're talking about negotiations, at least in a first step would be also cooperation, but have somebody internally who knows what to do, because sometimes you may come to an agreement easier between company and company. The moment you involve attorneys, it's more disputes, let's phrase it this way. So you have sometimes in the background, so I see that frequently. I'm drafting letters actually partly in-house and say, well, I don't send them out from my own letterhead, yeah, but send it out by yourself. And I draft it in a way that it's not immediately a patent attorney or lawyer style draft. So if it goes to negotiations, because negotiations means you have to have the best situation commercially for your company, you know that best by yourself. So at least have somebody there in-house as well who knows what it means.
Let's take this question from slightly another focus point. And what would you recommend to do in-house? Not, mandatorily, but you recommend doing that. You already said that negotiations are in-house.
Yeah,
but probably something else.
Yeah, I think it's an easy task to what you can do externally. It's information searches, analysis, and monitoring systems. So this is just an answer you get. So, for example, for monitoring, it's not a decision what to do with the finding on the monitoring. This is more the in-house part, but information searches and like most of the companies which I know, it is quite common to have a certain part of the applications drafting to be done outside. So these are easy tasks which are done. Yeah. patent prosecution, application prosecution and appeal proceedings, I would say, I would not say to do this as a kind of a recommendation, because it always comes to the point where you say, well, during the examination procedure, you have to change the scope of the claims. And when you change the scope of the claims, you know it's very of a big advantage to talk to your development department or to your sales department. Where does the product develop to? Can I do these changes, or should I try to find something different, which is easier for an in-house counsel than for an outside law firm? So.
Yeah, probably I also picked something which just immediately struck my mind: reverse engineering. Reverse engineering is engineering. It's not patent lawyers' work or patent attorneys' work. So you know better than we do. We are patent attorneys firm. I have a desk, I have a computer, I have my mind, I know the patent law and I know all the strategic approaches, but I don't have a laboratory here. So if in the moment you need that, you probably do that in-house. Also information searches, analysis, monitoring, especially monitoring. I think that was also really a task which was essentially done outside. Meanwhile, and there were also a question about patenting software that could be a very different thing. It could be management or just summarizing, but it could be also search. So frankly, the digitization and the availability of databases, meanwhile, enables you probably to do some searches by yourself and some monitoring. I don't want to give away business. We would be happy to do that. But I see a lot of my SMEs like monitoring the patent applications of their competitors by themselves. And then they think, well, look, I've seen something, Christian. This popped up. I don't need you to tell it to me that there is a new patent application of my patent competitor. I looked into it and said, well, we never do that. I can see that because I'm also now working from 5 years. Or he says, well, look, that may be critical. How could that end up? And then it comes to me. So probably that basic thing, basic searches, analysis depends on what it is, whether it's patent infringement analysis, you probably need an external one, but seeing whether it's relevant for your business and seeing what your competitors are doing, you can probably do internally meanwhile. And a lot has changed the last, really 3 to 5 years with all the information being more easily available. Well, you have to learn how to work with that. Yeah, but that is helpful.
Thank you, Christian. Gentlemen, tell us some sacred knowledge, how important reverse engineering is.
Well, reverse engineering. I think from our
I'm just out for a minute, then back.
Yeah. Just from a perspective of my personal experience, whenever you have to deal with IP, you come to a point where you have to make a decision. Well, do we really have an infringement or not? So then what you do is to get the competitor's product and to have a closer look at that. And depending a little bit on what you have. So especially important, for example, in here is a product by process claim or something like that. So where you have to really recognize and to find out, well, is it done in the way as the patent describes, or is it not done in the way as the patent describes? So internally, our company does a lot of investigation of competitor products for the pure sake that our patents should cover our products. And when you are within the automotive supplier industry, then the car manufacturers ask many suppliers, say, okay, could you deliver this product? This product should have certain sizes so that it really fits into the engine, for example, and has, of course, has some features in it. And if you do not get the order, there is a high probability that one of your competitor who got the order fulfills all these requirements. And of course, we have to check, does the competitor product then make use of one of the patents we claimed we filed in connection with this technology? So yes, very important reverse engineering, but not in the IP department from a perspective of copying something, but more checking are any of our patents used by a competitor.
Udo, can you say us something about reverse engineering in your particular field of art?
The chemical industry, you wouldn't talk about reverse engineering, you would call it chemical analysis of competitors' products. But in the end, it's all the same. So we, what we did is for a number of products, we check the competitor's product and look, for example, for trace elements, trace products, which give you a hint of how the chemical might have been produced, and which can be a first step into litigation, or at least for a discussion with the competitor. And definitely it's important when it comes to litigation, because then you really do analysis to the extent possible before you really start litigation. Because most of the discussions are about production or process patents today. I mean, the chemical itself can be analyzed relatively easy in most cases. So this should be more or less a clear case. But when it comes to production, it's much more difficult on the side of the patent owner to really prove that the process has been used.
Yeah, probably adding on that, that is really one point I also want to make. It depends on which technology you are in. So partly it's relatively easy. So my background is physics. So Udo, please correct me. I thought chemistry is easy. I can analyze it. Done. Yeah, so I see what ingredients are in there, but you're certainly correct. Manufacturing is already a very different thing. If you have a mechanical device, reverse engineering is pretty easy. You open and see whether it's good. If you're an ITC, if you need the source code to know what the whole thing is going to do, it's incredibly complex or partly impossible. So it really very much depends on which area you're in there. But one point is reverse engineering, or let's go one step back, knowing what the others are doing, and that can be partly done without reverse engineering, is always very helpful. And now we're coming already to monitoring. Probably it's good to monitor your competitors or companies or institutions who are doing something which is similar to yours, and to see their developments when just looking into their patent applications. You know what is coming up, you're getting a lot of information, so even a step before reverse engineering, which is when the product is there. So probably look also into the patent applications, and then you see what ideas are else on the market, because that's one reason of the patent system. You don't have to reinvent everything by yourself. You can build up on what the others are going to do. And if you see something interesting in a patent application or in what your competitors is doing, frankly, it's nothing wrong to say, well, why don't I do that by myself as well? I'm trying to find a solution, I have not found it, or I'm working on a solution and it costs a lot of money until to get it. Probably it's just in front of my eyes, and I have to see, can I do that or can't I do that? And that's again, patents. And if they don't file for patent application, well, it's legal to do so. If they filed a patent application and let it drop, fine, you can do so. If they have patent applications, yeah, and you think the idea is interesting, think about what can you do to have a similar result, but being out of patent protection. And that's a discussion I very much like for my SMEs. We're sitting together, they have a new product, say, well, that's our idea. We have already monitored something. These are patent applications. What status are they, Christian? Are they a threat to us? And then we are developing and seeing something. Yeah, well, we need a certain product with certain properties. How can we achieve these properties? And we have to achieve them in a good way, in an economic way, into a cheap way, which is accepted by the market and which does not infringe the products or the patents of my competitors. And that's a good task, and it's definitely worthwhile, because you get a lot of information you otherwise would not get. And reverse engineering is just one part of it, and depends on how troublesome and how expensive it is. And again, depends on the technology.
Okay, thank you. We have now a very, I would say, colorful world of IP services filled by lots of companies, including whom I name as narrow service providers. You definitely know them. There are filers, there are translation companies, rather old ones, known ones, annuity paying companies, application writers located mostly in India. And what potential benefits do you see in selecting them, or special ones of them, and what disadvantages do you see in that?
Yeah, I can start, and I would mainly concentrate on translation companies and annuity payment. I just can say from our company perspective, annuity payment service is simply a must. So it's something which we would not like to introduce the software, and also from a kind of a security level. So we have someone externally doing all that stuff, and you have one more opportunity to heal something in case something goes wrong. Translation companies is also when I started my career. So we had at that time a real nice IP division. They had 2 draftsmen, they had a translator to Japanese, they had everything in-house in the IP department. But things have changed a lot. So the IP department does not have draftspersons anymore, does not have translators anymore. These are services which can be provided by other companies for a very good quality at a real reasonable price, which not be beaten by an internal translator. What I think, especially if you think of these electronic translations which we now have. And the benefit for applications writing, as we have already been discussing, is of course that you have the opportunity to outsource according to the in-house demand. What are the in-house patent professionals needed for? And this may change for example, if you have a lot of litigation in-house, so there may be less time available. So it gives you room for briefing in the IP department.
I agree to Edgar's choice on concentrating on translation and annuities. For annuities, it is a must, yes, and it's checking the quality is relatively easy in this field. The only thing you have to do from time to time is to check whether the payment level is still suitable, let's say, or you should change the paying company. For translation, this is much more difficult. I can check the translation into Korean or into Chinese, not at all. So this is a little tricky. But nonetheless, we had translators in the company when I started. They are all gone, and you kind of have to rely on the big companies here to some extent. Can't be avoided. There is no choice. You cannot compete with them or build up your own group doing this kind of work. And filers and application, well, this is the consideration. What can or should your own attorneys in-house do, and what should be handled by outside law firms?
Yeah, probably only a short addition. I think annuity was quite well covered already. Translation is a moving target momentarily. It changes every year. And come up with machine translations. Are they good? Well, if you compare it with 2 years down the road or 5 years down the road, they're excellent. Are they sufficient for a patent application to finally work on it? Still, it's a clear no. Absolutely no. It could be just as a starting point, just to keep the foot in the door, provided that you are legally secure that you can file an enhanced translation, and you will have to do so if you go into examination. But the situation may be different in 5 years. So let's see what's happening there. So really a moving target. Filers. Difficult terms. So from my own experience, we really had, I mean, we're a private practice. Yeah, normally, traditionally, we did everything. We did translation. Yeah, when I started my career, I did translations as a patent attorney. Yeah, that was a patent attorney task. The translations were, well, I would say not only because I did, but the patent attorney knew the technology. He was translating in his own technology. He knew what a draft, a claim wording must be. So that was quite good. That business is done essentially because it's also getting too expensive. Yeah. But we even had a couple of years ago a filers. What is a filer? So that was actually a non-thinking working task. So hire a patent attorney who is giving his name, or meanwhile it would be his electronic signature card, filling out a form, sending him everything what you can do, like the whole application, and he just pushes a button. That's not possible for all cases, but there are some. Just to give an example, entering an EP regional phase where the application is already in the right language. So we had that as a private practice. I was, of course, not happy because we do a mixed translation. And frankly, the company switched back to that because there were too many errors even in that simple task, because nobody was thinking there, and don't have anybody working on case when they are not thinking. It's different to in-house external. If you file as a company internally, that's absolutely okay because you know what you do. If you hire somebody for filing, my recommendation would be don't do it. Either you do it by yourself or you do it with somebody who knows what he's going to do. Application writers, that means drafting. Yeah, as mentioned, yeah, it's a development. If you, for the example I've just mentioned from one of my dearest clients I'm working with for 20 years, they do it now internally, that's fine. Again, the knowledge must be there because the drafting is where you can do the most severe errors. If you draft something wrong, you can never repair it. So have good quality there. That's very, very important. Yeah. Actually, if you work on an office action there, yeah, you can do that internally because you can do not that much wrong, and probably the examiner will also help you. But if it's wrongly drafted right from the beginning, the examiner at the patent office cannot help you. Yeah, so do it internally. If you have good quality, then do it externally, and you outsource to that specific special services, only those things where you actually don't need the brain. Annuity payment is deadline watchings, yeah. Translations, as mentioned, moving target.
Thank you, Christian. Before we go to the presentation of Edgar regarding Schaeffler secret matters regarding how in-house IP service works in Schaeffler, let me ask you one more slide to comment. And this is selection procedures. How do in-houses select their outside supporters or collaborators, or however we name them? Should that be neutral or biased? Does your opinion as in-houses matter in that selection? Your personal opinion, your personal preferences, and what are the fair criteria on which such selection can be made? Years in practice, professional ratings, your own experience, anything else? So Edgar or Udo, who start?
Yeah, I can start on this topic. So if you talk about IP services, I would take it a bit more generally. So what are the IP services? Searches, for example, even our docketing system or the search system which we use. So, and I remember very well when we came to the decision that we wanted to change our docketing system. So we had a lot of criteria, what should be fulfilled, what should be used. And then, of course, you have to compare all the providers which can provide you with a docketing system. And then you do a decision on, well, what is fulfilled and what would be the expected costs on a mid or long-term basis also. So this is I think, quite easy to do. As soon as it comes to how do you find out who is your cooperation partner in a law firm, it becomes much more difficult. And I'm quite sure that there is one important point within the companies here, at least within our company, and I think it's quite common in all the companies, neutral. So because if you think on compliance, so it should not go like this. So this is one of my best friends. He has a law firm, and I think he should work for this or that company. You cannot do that anymore at least in our company. So there must be some neutral approach. What, as I've been telling before, so how big is the company? So what will happen if this single person, for example, is somehow sick for a couple of months? So who will take over and all that stuff? So this is important. And what is our impression that this law firm is the right choice for this technology and the right choice for the purpose? So there is a difference, of course, between patent drafting and patent litigation.
Yeah, only a very few additions. I mean, you have your processes on how to select certain companies for certain services. They are given in a company and they have to be neutral. So the only thing you can bring in from your personal experience is something we call a bonus or malus system, where you can say, well, when a certain company has the same price as another one, are there certain benefits we received in the past, or is there a very good experience with this law firm or not? Maybe it also goes to the other side, but that's it. You can't select your buddy, as Edgar said. This doesn't make sense. It has to be a professional process with all the criteria listed, then you get a price. And we even in some cases had a certain period of time where we simply tried with a low number of cases and decided after half a year of experience where we got a better feeling how the service looks like in practice.
Yeah, only a few comments from my side. I think clearly buddies is the wrong decision, and it was always the wrong decision. And I'd say I have very, very good friends. I like to spend my free time. It's not that much, but I like to spend my free time with them, but I don't want to work with them in my own firm. And I don't want to have them as a partners because I think they're not suitable therefore, and still they could be friends. So that's kind of the one thing. So it must be neutral. That means you have to have a professional assessment to that. Just coming again, it depends on IP services. Well, if it's just renewal fee payment, well, I'd say it's not a highly complex case, so you don't have to have that much brain. But frankly, it has to be reliable, because if you miss paying a renewal fee, it has terrible consequences. So you don't need brain for that, but you need a very reliable information. So it depends a little bit on which area you're looking for the IP service. And I would say, well, probably you can check. I don't know how much errors are reported about some companies doing renewal fee payments. So that can be probably on a neutral basis checked. And here I fully agree what they've said. And then there comes only, in addition, there's also one aspect where it's getting difficult to be neutral, and these are the soft factors. So checking, you have kind of all the neutral things, what you can ever check on experience, which is on hard facts, which you can see they are reliable. They do that for quite a long time. They have all their professional background. Still, I have a selection of 1 or 2 or 3 where I would say, well, I don't find a hard factor where I could make a decision. Then, I say that cautiously because it is not buddies, but it is assessment of soft factors. And that give me an example. If I do not know and I have 2 or 3, I would also rely on recommendations, and these are on soft recommendations. So if I go to Udo or also to Edgar and know they are thinking about the same as I do in responsibility and kind of work, and I would ask them and say, well, look, do you know one of them, and do you have a recommendation for one of them? And hopefully I would offer the same thing the other way around. And I'm frequently asked also from clients of mine internationally, and they're saying, well, look, I want to work in that country. I don't do it via you, I do it directly. So it's not a business of mine. Do you have recommendations? Then I could still say, yeah, well, we're working with them for quite a while together and know they're good in that technology. We know they're not good in that technology. So try to still collect the soft factor information from people you rely on. That is not buddies, but that is you ask somebody who can trust, who is not recommending his buddy, but who is recommending somebody who would himself say, I would cooperate with them if it would be my decision. So that's the final point on the soft factors, which are very difficult to judge.
Okay, thank you, Christian. And now it is time for Edgar to tell us about Schaeffler as a company with excellently working in-house IP services. Edgar, your time, and you just say me when to move to another slide. You are in mute mode, Edgar.
Now you can hear me again. So it's just a short overview. What you see here, it's Schaeffler is a company doing quite more than 10 billion euro. So last year it was 12.6 billion euro. We normally file something between around about 2,000 priority applications per year. We have more than 10,000 products in place, 83 or 84,000 employees worldwide. And what is not written in here is we get something about 3,000 invention notifications per year. So that's the point where we have to work as an IP department, more than 10,000 different products and something about 3,000 invention notifications per year. So if you take just the next slide. So this is just a view on the world map. I just wanted to draw your attention to the left lower side where we talk about the regions and the R&D centers. So R&D centers are in Europe, in the Americas, in China, and in Asia Pacific, which is for an IP department is a big challenge, because on the one hand you have to deal with all the patent laws of these individual countries, how to deal with the inventions, and on the other side you also have to regard some formal aspects like the obligation of first filing and so on. So can you take the next slide? Just a little view on the products. So originally Schaeffler was founded and dealing with bearings, with all different kind of bearings. Then it turned into as a big car supplier. So Schaeffler does about 70% of its business in the car supplying business. And the second industry is the remaining almost 25% is industry sectors, and industry at Schaeffler is wind power plants, aerospace, for example. The main bearing of the A380 comes from Schaeffler, some off-road road two-wheelers or power transmission, and in industrial automation, as you see that. It's just a rough overview just to give you some impression. So, and next slide, please. So when we talk about the object of the IP department, we always come from the first side. Okay, what is our obligation with respect to these 10,000 products? And the obligation clearly is to minimize the legal risk which might arise out of the fact that the products might infringe any third parties patents. So FTO investigation is one major object which is done at the IP department here. And then our second object is to secure, to create an effective patent portfolio and to manage this patent portfolio and supporting the business divisions in their business opportunities. And then we come to the point where we say, well, we have to secure the business advantages, of course, and if we are forced to, we even enforce our IP. So next slide, please. And this is just kind to give you some impression, global figures. And I have, what I can show you here is a couple of years. So from 2011 to 2020, we had something about, just on an average basis, saying 3,000 or between 2,000 and 3,000 invention notifications. We always file priority applications at the DPMA, and are second in the statistics of the annually filing here in the German Patent Office. And as you can see below, we do a significant part lower of international patent applications. This is something always between, so let me just say, on an average basis, about 500 international applications, which we do normally as PCT applications. What you see here is the work which has to be done within the IP department. And just some figure for the IP department. In Germany, we have a size of about 50 people. We have one IP department in China, which has 9 people. We have an IP department in the US with 7 people, and we are building up presently an IP department in the rest of Asia Pacific, which will end up with 5 people. So if you could give me the next slide, please. I think I show you the two main processes which we follow. The first is to minimize the risk. So we do a continuous monitoring of relevant IP or IP which might be relevant to the present products which we are going to sell, in addition to the products which might arise out of R&D. We do searches and landscaping, and of course, if necessary, risk evaluation and FTO, and arising out of that, invalidation actions, oppositions, and sometimes licensing and licensing negotiations or litigations. Within the field of creating our own portfolio, we have established the following process, like we evaluate the invention disclosures. And if you look at that, and you have to deal with 3,000 invention notifications per year. And our experience is that one individual patent attorney can deal with something which is a number between 100 or 150 invention notifications per year. There's a lot of work to do internally. We do a drafting of almost today 1,800 patent applications. We do the prosecution, more or less, aside some very, very rare cases, completely internally. What we do then is we evaluate the granted patent, and where we say, well, is it used? Might it be used in the future? And after that, we do a 2-year or 3-year IP dialogue in order to check, does this individual patent really help the business in order to be more present in the area of sales, which means, is the market, and we have been talking about that a lot, is the market the right market? So do we have this patent in China when our market is in China? So I think this was almost the last slide, right? So
thank you, Edgar. Very impressive figures. It looks like your company files more PCT applications than some countries of the world receive annually. And their budget of foreign filing is almost the same. So it's very impressive figures. Gentlemen, before we go to the questions, which we have not too many, but we do have them, let's discuss one. It is last here in the roundtable, but it is, of course, not that less important. And this topic is how do we evolve? How do we teach each other in houses and outsides? what are, how much does mutual education mean, and what forms of it are now used commonly or preferably outside council meetings, visits to outside council firms, introducing new technologies to outside councils, information updates, joint seminars, anything else? What can you tell about that? Maybe Udo can start.
Yeah, sure. I mean, you need this exchange with the internal councils, otherwise your cooperation will not be as good as possible. How you do it depends on the case. This can be done on a specific case where you might even invite the outside counsel to the labs, to the production site, just to get an impression, to have a personal discussion with the inventor. I mean, today with the video conferences, you can have the discussions anyway. But what we saw is that a visit on the site, how it really looks like in action, is something helpful, let's say, for the background of the council. We also have had and have regular visits by the firms bringing the latest developments in their countries. So maybe changes to the patent law. What does it mean in practice? Do we have to observe? So it is done by the outside council. And yes, we also had joint seminars from time to time, especially when it comes to litigation, not to really learn all the details of litigation in a certain country, but learning those aspects which might be influenced by us when we write the applications. What should we consider right from the beginning when it might come to litigation at a certain point in time? This is something which can be done very nicely in joint seminars where you have questions and answers going on and on. So this would be my key messages here.
Yeah, to add here a little bit, it's only we more or less do the same. So I think also that especially the site visit gives a lot of impression what is really going on in development, how is it done, to see the products, and it often makes very clear that a drawing, so a technical drawing especially, is not the real world. So they you get much closer to the product if you really see it. What we sometimes, in addition to that, do is to invite one of the specialists of the outside councils to give a kind of a seminar or so internally, so that we have quite a good exchange and you get closer to each other and have and get some knowledge about new developments. So that's the only thing which I think has is something which is done here internally.
Yeah, I can only complete to that communication between the entities or the people cooperating with each other, and this is what we're doing is very important. And again, it depends a little bit on the company, how formalized you do it. So just giving a few example, I have one of my largest clients in the United States. They had for many years, and still they have it now virtually. Really, they call it outside council meeting. That's what they mentioned. And people, the attorneys from all over the world flying in, and there it comes the exchange exactly as we've just heard. The one is the company tells them, look, this is where we are going to. Here you get information which is not public. So you have also that NDAs and whatever, you get information where it said, well, don't make video, don't look into that. That's our ideas where we're heading for, which is important, what we're going to do business-wise. This is the technology important, therefore. And of course, on the other way around, we talk, and now I'm talking as a private practice person, talking about are there important aspects in law development, which you also have to take into account. So these were meetings which were 2 days, yeah. And as always, we're all busy. We're all busy, yeah. We think it's very good. And if it comes so far, you say, oh God, 2 days in just talking, but it's so important to have that. And if you leave that meetings, I think it's you know that they, yeah, exchange information, which are important for both sides. You have that also in smaller and medium-sized companies, and probably not that formalized, but that exchange is very important. So all to the SMEs I was talking about just earlier, where we're kind of discussing it. I'm regular at their premises. I go there and talk to the people who are the direct contact persons. To me, that means who are mainly responsible, not as patent attorneys, but as responsible for that interface to me as an outside counsel. But I'm also talking to inventors, to researchers, etc., to keep that communication open. And then, of course, I mean, if I give presentations there, it very much depends on who is listening. So if it's somebody who knows about patents, then I can go into the details. If it's just an R&D person who is normally not involved in IP, then of course the topics have to be on different levels. So choose the right topic for the right persons. But the exchange is extremely important and helpful for both sides to, at the end, have a good and optimized result. And that means understanding of the situation in both directions, even if you don't go into the details.
Thank you, Christian. And then the question which completes our today's roundtable, but it is, I think, directly aimed at Mr. Meyer. What international IP professional organization would you recommend for?
I mean, you would be surprised it wouldn't be LES now, I guess. Christian being the past president, Edgar being on the board, and me currently being the president of LES Germany, the answer has to be LES. But seriously, I mean, there are more around, no doubt. But why should you consider becoming member of those organizations? Because you get all the information and you get the network. So this is really, in a nutshell, what it's all about. So all those good organizations have their conferences, maybe a little less now with Corona, but definitely on the webinars and those events where you discuss current development, latest case law and things like this. And the other thing, having a network, is just having this informal exchange over the coffee and asking, well, have you had a similar case? What can you recommend? As Christian said, do you know a specialist in, I don't know where, in Asia, who could do this kind of work? What kind of translation can you trust? And those things which really help you improving your own performance in the company. So there is a lot around when it comes to those organizations.
I think there's not much to add. Maybe the only thing is that one advantage, if we can talk about an advantage of Corona, is the development of our digital capabilities. So it's easy to participate on seminars, to participate without too much travel effort, and I think it's much more, from this perspective, really valuable to a member of the LES, maybe LES International or LES organization, and to take the opportunity to go through all the seminars which are provided and to draw the best out of that.
Yeah, I can only repeat, but I don't want to repeat what Udo and Edgar have said. So it's kind of the step beyond. We've talked about the direct communication between the company and its main outside counsel, which normally is typically there, or the multiple outside counsel if it's a larger company. That takes care of your immediate business needs and your developments. But of course, because the future is developing in a direction you don't know, it's good to get something more, and this you get on those events and from those organizations preparing you for what is going to happen in the future, which you may take into account during the direct communication. And let me add one thing, and we're sitting here electronically and all switched on. That's a good part. And that helps, as Edgar has mentioned, without traveling requirements. So for each of us on our sides, on your sides, it's just a couple of hours. If you had to travel, it's more time. So it's good for getting some information, but we also have to say, and that's my hope for the future, probably not as often as it was in the last years, but a personal meeting and discussion would also help, because the soft factors would come into play. And then you would talk to Udo, to Edgar, to Heinz, to you, Yuri. You can talk about many things which you don't do on that public screen. You're sitting thereafter together, you have a discussion which comes in between, which you probably not directly related to the topic. So the direct communication is still something which helps a lot to, over the years, develop information and get information. And those events are just therefore that you don't have to travel through all over the world and to all the experts sitting somewhere, but the experts coming together and talking all the time, not 24 hours, but 16 hours a day, if it's a more than one day event, and talking about all those topics. And at the very end, that also helps. So gather your direct information to a specific topics from these online seminar, but networking and understanding and judging the soft factors or soft qualities people you're working with, you can best do in personal meetings, if that is possible. And I trust that it will be, at least to a certain extent.
Thank you, gentlemen. We made it, I think, and made successfully. And here now is time for responding to questions that we received. I slightly grouped them, so I will not repeat all the questions, and I will repeat those which encompass others of a like nature. So the question is, I'm reading it. I'd like to ask a question about one issue appearing in-house. For us, in a Russian manufacturing company, primary identifying by creators of objects capable to be protected as IP and bringing them to the IP department is a huge problem. I'll be very grateful if you tell us a little about how, in your practice you are familiar with identifying future IP technical solution is working. Who is responsible for timely considering objects being valuable and needed to get protection? Which departments are included in this process, and who is in charge of this process? So who takes the lead?
I can start if you like. So, I mean, this is really getting the basic information about possible inventions out of the R&D community or out of the development. That's one of the key tasks, I think, of the in-house attorney. So send him into the R&D discussion, send him in where the results of R&D are discussed, send him in where the budget for R&D is discussed, because their R&D will really tell what where they were successful over the last time and maybe not. So we were very successful in bringing our attorneys into the R&D project discussions, or whatever the term is, where the inventors meet and where they discuss how to proceed and what they did successfully in the past. And this is, I think, the place to also give information on IP and telling maybe that the invention is not yet at a status where you should think about filing, or the other way around, you say it's about time now, let's discuss who can provide information for the application and so on. It's the link we discussed between the IP department and R&D, and this is something the IP department has to start, because the inventors, well, they invent, that's their job. They not necessarily turn to the IP department. And what you can do to trigger a little bit more, you can set up award systems like Inventor of the Year or Invention of the Year or something like this, so that people have this IP link in mind when they do their job.
Yeah, I can add only. I would like to add only with respect to the question who is involved in the decision. So of course there are certain ways to do that, and normally IP department has the responsibility to clarify what is the point of the decision, but necessarily does not decide all by itself. So you normally put up a kind of a patent committee where different disciplines are in, like sales, so that you can decide, well, is this something which might help in the future if we have a sales, and then there a common decision is made, well, do we need is it helpful to have a patent application, and if so, in which countries? So that's what I would like to add.
And I would probably again emphasize what Udo has mentioned. And while he was talking, I said, well, actually, these were my first weeks in the company where I was trying to build up an internal patent department. First, getting the knowledge around, and that means the internal person has to go to R&D people, go around, talk to them, bring the information and say, well, look, you're not only inventing, and partly they do not even realize that they invent something which may be patentable. For them, it is a normal development. That's what I'm here for, not realizing that it's even a step beyond and that you could do something very, very good for the company as well. Second thing was also came up to me is, well, people do that because they want to help their company, but incentives like Inventor of the Year does not necessarily have to be money, can be money, but acknowledging what they are doing is so important. Giving them a feedback and saying, well done, is more important than you think. And we always have to keep ourselves in mind saying, acknowledging and saying thank you what they are doing, encouraging them to do so in their multiple ways. And last thing is also depend, I mean, if you have 2 or 3 people to talk about, well, you can keep the connection close. If you have more researchers, also after you've told them what they can do and what they should do and that they should take care of, it comes up a week later, 2 months later, half a year later, give them an easy way to report to that. Because if they say, well, I have heard something, but I don't know what to do with, I don't know whom to talk to, give them an easy way and say, well, look, if you have an idea, here's a tool, here's a form here on your computer system in your intranet, just send a letter, here is IP department, I have an idea, can somebody come to me, or you provide a form, what do you have invented? But in basic thing, well, I think there is something, can somebody talk to me? So give them an easy way to trigger the process, because you don't see it every day. And then probably the whole thing is going to run. Great.
Next question is about subordination of the intellectual property department inside a company. Whom in a company should the intellectual property department report to? Who should set and coordinate the tasks of the department? Should it be an executive, marketing, R&D, or whoever? What is most effective in terms of the company's objectives?
Well, it doesn't matter. With my organization, I was in R&D, and the IP department was in R&D in BASF for about 125 years. And then we moved to legal, and it didn't change anything. And now I know that the IP department is part of a service unit. So in the end, it does not matter. What really matters is how you are treated and how your boss, being responsible for IP, thinks about IP. And this is the key task, I think, of the head of the IP department, to again make visible what the IP department creates, what it is for, and how it supports the business unit. Whether this is someone from R&D or the chief legal counsel, in the end, it does not play a role, I think.
Yeah, I would clearly agree on this. I went through different companies where we also had different reporting lines. So presently, we here are at the in the area of our CTO. So we are one organization within the CTO organization, so which works pretty good. But there are others, other organizations which I really know from colleagues. May be the legal department, for example. But I completely agree. It doesn't matter. It's really just important to show what is the value contribution of the IP department?
I also agree, but with an emphasis on the second half sentence both Udo and Edgar have mentioned. It doesn't matter if the person responsible therefore understands the importance of IP. And yes, and then it doesn't matter if you have a good person there acknowledging IP, seeing what the value is, and also having a basic understanding. It doesn't matter what on the organigram is standing there on department. Frankly, if I look around through the various clients of mine, normally, normally I've seen more understanding on the higher ranking area if it's part of the R&D level because they understand technology. But this is only the suboptimal situation. Yeah, as mentioned, if you have a good person on top and acknowledging that, and that should be probably up to the board, and that's always very good. Yeah, and we see companies, if on the very top management level, if they understand IP is important, it's important for us, then it goes down the whole range because the top person, the top manager, the CEO, whoever it is, knows the importance, then he will teach everybody, whether it's legal department or R&D department, that it's important, then it scrolls down and everything works fine. I have seen more things failing if it was in the legal department than in the R&D department. And that was probably because of the wrong person sitting there in the legal department. And if you look into attorneys at law being there around the world, there are quite a lot, and very, very, very few only understand intellectual property and patents. And this is probably a problem with legal in principle, because for legal, IP is just minor thing. But for R&D and development on the product, normally patents or developments are already more important and have more knowledge there. So if you grab into the just area, it's probably easier to pick a technical person, R&D department, acknowledging this important part of IP than in the legal department. But again, it's acknowledgement and knowledge, and wherever you have it in the organigram at the end does not play a role.
Thank you, Christian. And now we have two questions regarding the patenting. And the first one is, what is the situation in Germany with patenting software? What is your personal opinion on the actual need of patent software? I would slightly rephrase it because otherwise the answer will be too straightforward and short. How it is about computer implemented inventions in Germany?
Shall I also start? I mean, you have phrased the two terms already. Software as such is not patentable. That's what the law says in Germany at the EPO. So the term is computer implemented inventions. And yes, you have an additional task to bring over, that it's not only just simple software, which is probably copyright protectable. So it may be easier, or you have one additional step when you compare it to mechanical engineering probably, or real physics and hardware, or also chemistry. I think one hurdle you don't have there in computer implemented invention, you have an additional one, which the basis is that the patent law was for technical inventions, and all the patent laws all over the world have been made at a stage where nobody knew a computer. And so this is why you have to bring up the patent law and match it to the newer developments. But as an overall statement to everybody who is listening and say, well, I'm working on computer implemented inventions, can I protect that? My clear answer is yes. Yes, it's yeah, you have to take care for some things. And so it may be even more difficult to draft a patent application in a correct way than for mechanical. So for mechanical, it's probably easier than for computer implemented invention. But yes, these are protectable and you should definitely try.
Thank you, Christian. Edgar, would you like to answer?
I just wanted to say nothing to add from my side. So it's really a complete description of the situation. So
okay. And one last question, and it equally relates to all of you because it is connected with the leakage of information regarding invention. Although it's formulated rather narrowly regarding could there be any ways with the European Patent Office and German Patent Office for filing an application for an invention if the technology had been probably disclosed within 6 months Again, I would add to that that of course filing is possible, but what the consequences will be. So just few words in your own experience. Let me slightly broaden this question. When the leakages frequently happen, how to avoid them, and what to do if it happens?
Yeah, shall I start shortly? Probably it's kind of legal question. A very important point for everybody who is new in this business, especially if it's talking about universities or research institution who not only think about business, but also for publication and papers. Make sure you file your patent application first and then talk about it. If you have made your own publication in beforehand, where you really fully explain your invention and that is publicly available, your patents essentially all over the world are at least at risk, and in Germany and for the EPO, they are simply dead. So you have an absolute novelty requirement. So this is also something what your internal patent department and your in-house people have to bring over to everybody else working on that. If you have a new idea, talk first to your in-house lawyers, think about securing it. You have some countries in the world where you can have a grace period, yeah. And if you can use that, that is nice. We don't go into detail for each of the countries. Keep in mind there are some, so it's not lost for each and every country, but especially for Germany and Europe, it's normally lost. And please keep in mind it's also lost if it's your own application. So it may sound unfair. That was my idea. Here's my publication. Why don't I get a patent therefore? It's just these are the regulations. A final point is if it has happened in Germany, you have the utility model application. And in the utility model application, you have a 6 months grace period for your own applications. So this is partly happening, kind of a fallback position. Don't go into that situation actually on purpose. Think first about publishing and then probably filing a patent application in beforehand. But if you have missed that, or if you have noticed 3 months too late and say, well, I should have filed for an application, now it's too late. In Germany, you have the utility model application, and that gives you a 6 months grace period.
But also here, I think publication before application is quite dangerous, and if you give that small help here with the utility model, then you are restricted to the product. So it might be even more difficult or very difficult as soon as it comes to software implemented inventions. Yeah, so I think, Christian, your first hint, first file first and then publish is much better. Yeah,
it's always good. As mentioned, the utility model is, oops, I noticed too late. Then you don't give up. Think about that, but don't do that on purpose. Then first think about filing, then publication. Absolutely clear. Fully agree.
Okay, gentlemen, we finalized our roundtable. We have no more questions, but probably they will come later, and we will respond to them with your assistance, especially when if they will be about very, I would say, delicate questions of in-house services building, creating the systems. Thank you very much for your participation in both roundtables. It is, I can imagine how difficult that was for you to allocate those good morning hours for our webinar, but you did very important task. Thank you very much. Let me applause to all of you, and let me wait to good times when we have again no restrictions on travels, to see and to have you all here, and to be able to talk in person with our attendees, also including the events with whatever international organizations we invited our listeners to join. Thank you very much, and let me announce another. We leave our current presentation, and you all are invited to go to another roundtable on university licensing and development practices. And let me wish you all success in your professions, and staying as long as you can in that fascinating field of IP, profession of IP rights and of creativity, of human creativity. Thank you very much, and have a nice continuation of our today session. Thank you.
Thank you. Bye-bye.
Thank you, Yuri, and thank all participants. I know it's a complex topic, but contact Yuri and he will be perfect to answer. We know we could not answer all questions. It's just, yeah, a starting aspect, and we want to cooperate. Thank you, everybody.
Thank you very much.
Thank you.
Hello, everyone. My name is Sergey Medvedev, and I'm the partner with Gordisky & Partners. And let me continue this session of roundtables on our first day devoted to patent rights and patent law. And please take your another cup of coffee and join another roundtable of ours, which is devoted to universities, R&D, and current licensing practice, which we may encounter in Russia and in Germany, of course, since a foreign experience is always nice to promote IP on the global level. And this roundtable will start from Professor Heinz Godard, who can talk a bit about university rights and especially patent rights, which they can create and then license. Professor Godard, please take the lead, and we can of course be very active since it is a roundtable, not a lecture. So please, if you have any rights issues or want to discuss something in particular, let's do that right now. Please.
Yeah. Thank you so much. I will, I think, do it in the following manner. I will talk about the legal situation in Germany first, and later on, maybe our industry participants will have not the opportunity, but there is a necessity that they do so as the major players in industry-university cooperation, what in their practice they actually do in Germany in terms of licensing or of cooperations between industry and university, leading to certain results which are patentable, licensable, etc., how this is done in practice. The legal situation is very simple to be explained, and maybe if somebody wishes to switch slides, you take my slide number page 2, and we can use that. I take a few of the slides which I sent to the organizers, and page 2 maybe is a good one, but I can also do it without. Until the 6th of February 2002, as many of you will know here in the audience, the industry-university cooperation in Germany was pretty unique, which led even particularly authors from the Anglo-Saxon world and particularly from United States to the conclusion there is no, let's say, profitable for both sides industry-university cooperation with regard to R&D in Germany. The reason being, if you go into the registers of the German Patent Office before 2000 and 2003, I would even say, you will practically not find any patents held by German universities. So the simple conclusion of some authors, particularly from the Stanford world, etc., they said, oh, what a pity. We have now in the United States this wonderful Bayh-Dole Act. We do industry-university cooperation. Industry makes the inventions. Universities make the inventions. Industry licenses this in, and it is profitable for both sides. But the Germans apparently didn't detect this yet. Well, this was not quite true. Until the 6th of February 2002, we had an absolute professor's privilege in Germany. That means thanks to a law which was given, I would say, as a donation by the Empire government of Germany in 1942-1943, within the framework of a certain regulation, which later on was the basis for the presently existing German law concerning inventions made by employees. It was explicitly in Article 42 thereof made clear and sure that inventions by university professors, lecturers, and what we nowadays would call assistant professors are so-called free inventions. That means these inventions were privately owned by the inventors. The university couldn't get hold of them, but the inventors were free to cooperate with industry by so-called, usually done, consultancy agreements, which had a, what interests us here today, major content, namely that the inventors get money and industry gets the inventions. These inventions very simply were then filed for patents in the name of industry, very often not mentioning the inventors, even who did not wish their, let's say, scientific independence jeopardized by mentioning them as inventors for a certain company, whether a German company or external company. So there was university inventor inventions, cooperation related relations between industry and the inventors, but not with universities.
Heinz, soll ich das unterbrechen? Brauchst du deine Slides? Magst du sie, University Industry Cooperation? Weil ich könnte sie teilen, wenn du sie haben
Yeah, I would like to have page 2 thereof, as I said earlier, but if you can share this, it's nice.
Seems so. Let me
The
try.
whole presentation is called University Industry Cooperation in Europe, Germany as an example. That's the one. And if you go to page 2 thereof, that would be great. The pages are at the lower part of each page. You go to page 2 now. Exactly that. That is enough. That is enough for the moment. Since the 6th of February 2002, there is no full professor's privilege in Germany anymore. Rather, since the 6th of February 2002, university inventors have to notify, but I come later on to an exemption, their inventions to their employer, which is the university in this case, in the broader sense. And the university has the possibility to claim or acquire such inventions. If the university takes these inventions, notified to them by the professors, the university is entitled to evaluate, or let's say to commercially use the inventions, to license them out, to sell them, whatever they like. And if they do so, the professor, I call them now professor, also other university inventors, employees of universities are involved here, has the right to get 30% of the BRAT or overall income the university gets out of the commercialization of that invention. Make it simple. If the university sells the invention at 100,000 today's currency euro, then the professor gets 30% of that. If there's a group of inventors or professors or whatever, they get altogether 30%, and 70% are with the university. So no problem. Very clear situation, apparently. That means since 2002, universities can directly cooperate with industry. For example, that an industry partner fully finances a certain research project at university, and you can then decide in a cooperation agreement between university and industry what the rights and titles and payments also with regard to the respective invention and then patent are distributed, in which manner they are distributed between industry and university. There's one tricky, however, very tricky exception. You see this here in this slide, that the professor still has the right not to publish. That means if a professor decides in his, let's say, worries that his invention might be detrimental to mankind, he does not wish to publish. That does not happen too often, be sure, because professors usually need to publish in order not to perish. That means if you wish to win a Nobel Prize, you must, as early as possible, we all know this, publish your invention. But for whatever reasons, it is absolute outflow of the freedom of research and teaching according to Article 5 of the German Constitution that the professor in his wisdom decides, I don't wish to publish. In that case, he or she has not to inform even the university of the invention. Rather, the invention remains in the corner, secret, in the private cabinet or whatever you like of the professor. You will immediately see that this makes it impossible to conclude between university and industry an agreement of the following kind. Industry comes to university and says, I wish to do joint R&D. Actually, you should do the R&D and I will fully pay for it. And the results thereof, as far as patentable, should be owned by me. And you undertake, dear university, that all the inventions made under this project, which I fully finance, are given to me. And of course, I am willing then to pay the 30% provided by the law, no problem. University will come back to industry and say, oh, I am so sorry, I cannot sign this. I can only sign a document, an agreement where I promise to give you all inventions I get hold of, which I get if I don't know these inventions. If I can't acquire them, I can't give them to you. I'm very sorry, I can't. Industry comes back and says, no, no, that's not what we wish. We wish really all inventions. Why don't you put into the employment contract with the professor the obligation that he has to renounce his right not to publish and gives all inventions to you? And then the university will come back and say, oh, I'm so sorry, but this is because of constitutional reasons prohibited in Germany. He is free to decide whether to publish and thereby to decide whether to disclose the invention to me as university or not. But you may be in a better position if you go back to the professor, I tell you who it is, and make with him a contract, maybe a classical modified consultancy contract as you did in the past before the 6th of February 2002, where he renounces towards you, dear industry partner, that he undertakes in future to disclose all his inventions to us as university, and then we can get hold of it and give it to you, etc. And industry goes back to the professor, and the professor said, okay, no problem, we can make a deal. But as all deals in this world, that costs something. So the professor is entitled to renounce his right not to publish, and opposite to that, to give all inventions to university towards the industry partner, the financing part of this industry university cooperation in a broader sense we are talking about, which is a declaration which is not prohibited under German law. And that makes it immediately, to all of you, understandable, I think, necessary that there is either, it is under German law actually not a trilateral agreement. It is two different agreements which are made. One between university and industry, where university promises to give, thank you, that's exactly the one, where the university promises the industry to give them all inventions they get hold of, against certain remuneration, compensation, whatever you call it, and a second agreement, which is between the professor and industry, where the professor promises not to make use of his right not to publish in the broader sense. And since this is apparently a rather complicated arrangement, maybe we take the next slide now. There have been many attempts initiated by the German government in early 2001 already, which had the aim to make it unnecessary for universities with lack of sufficient experience to negotiate general cooperation agreements for R&D and the results thereof with industry to go to expensive law firms, not like ours, but sometimes they are very expensive. But to have hopefully some model agreements available, some not master agreements, but module-like model agreements, which could be used by a university and by the industry partners simultaneously, or on the same token, so to say. Smaller companies, particularly the backbone of German industry, the small and medium-sized entities, who have no experience to negotiate with universities, complicated trilateral agreements of the type here in question could be helped also by such a collection of model agreements. And as a consequence, the first trilateral contract which came into the market was the BMWi contract in the last line here, which has nothing to do with a beloved, and I have myself a car from 1996 built by that company, BMW. No, it is just the German language abbreviation for Bundesministerium für Wirtschaft und Energie. Well, this will change soon. It is the German Federal Ministry for Economy, and the energy will probably go away. This will become, with the building of a new government, will be changed. It was at that time just created because Mr. Stoiber, the then still Bavarian Prime Minister, wanted to have a bigger ministry than the ordinary Ministry for Economy. So they added energy into it, but it did not play a role in the development of this BMWi contract. Later on, the first contract, the predecessor of the BMWi contract, was actually a so-called Berlin contract. You find it in the first line, and Berlin contract and BMWi contract are pretty similar, except one clause I will later on describe to you. And the BMWi, maybe we go to the next page, the Berlin contract and thereby also the BMWi contract have one common feature. Namely, that typically in the model agreement, which is used for this type of cooperation, it is regulated that the research results, if the major part or even the full part of the financing of the research project, which is done at university in cooperation with a financing industry partner, that the results thereof belong materially exclusively to industry. That the first filing, typically a German patent application, which could also be a European one, but no reasonable party does this because of the high cost for first filing, which are caused if you go to the European Patent Office. My colleagues here today have talked about this already. The first filing is done by university and industry as joint applicants. It was controversial in the 2 years of negotiations which led to the Berlin contract as the basis of the later BMWi contract. The solution came by a proposal of a company which is known to everybody here, I think Bosch, who said, why don't we have university and industry as joint applicants? Because that had for the universities, and still has, the advantage that they are named as an applicant of primary filings, and the number of primary filings of patent applications by German universities is an important component for the decision how much money that university out of federal resources get in order to promote R&D, to finance R&D at that university. And industry has the advantage that they are sitting in the driver's seat with regard to this first patent application, because they are a co-applicant with industry and have from the very beginning of taking care of the application and later on prosecution and patent grant, the possibility to influence in a decisive manner, together with university, the fate of this German patent application. And now, very important, the foreign filings, that means claiming the priority of this first patent applications, is done according to the Berlin contract as well as the BMWI contract of 2007, done by industry in its sole name. So you find in the German primary filing patent application, primary filing based patent application, still the name of both the university and the industry partner. In the foreign filings, only the name of industry. The financing is usually done by industry. There is a lot of separate provisions in these model agreements. And if you go to the next page, you will see something which it is number 6. There's also provided for what should be paid for typical results of R&D done at universities financed by industry. That industry, on top of what is paid for the project financing as such, 2,500 euro are paid after a first patent application has been filed by industry and university together based on that application, and that between various alternatives, later on additional payments come, either a second lump sum of 2,500 euro at the start of commercial use of the invention by the industry partner, latest, however, 7 years after the filing date, or further lump sum payments when reaching turnover milestones, or, for example, milestones in preclinical and clinical trials of pharmaceutical inventions. And the last alternative is, as soon as commercial use has been started by industry, a reasonable remuneration is paid, typically a license fee. And it was interesting to see in the round of 25 parties negotiating the Berlin contract, which I was the chair of this working group, and later on, nearly without an alternative, I became also the chair of the still today working standing working group for R&D model agreements and research corporations at the Federal Ministry of Economy. It was interesting to see that chemical and pharma industry, practically without exception, voted and started using, and still are doing today, that a license agreement is contract, that license conditions are introduced into the cooperation agreement, which is the reasonable remuneration still to be negotiated. And there are samples for this, for license contracts, which are usually or very often even used by the parties, whilst in industries like car industry, particularly there, typically a lump sum payment in total is chosen even, which then anticipates even the second 2,500 euro already. That means, in other words, the result of the R&D project, which is financed in that case 100% by industry, is typically bought by industry, and thereafter industry is free to do with it what it likes. It was interesting to see how the demands, how the proposals of companies from car industry, including also part suppliers like Bosch, etc., had a very differentiated viewpoint, different, I would say, from what industry in chemical and pharma industry had. Where do we stand today? Maybe you go a little bit further, and I don't wish to go all these slides here. I give you now, I would like to go on to page 9 of the slides here. We have in 2007, after intervention by the Ministry of Economy in cooperation with the Chancellery in Germany, in 2005 it started, when under heavy consultation, I would say, or not pressure, on recommendation by Mr. von Pierer, formerly the CEO of Siemens, the Chancellery instructed practically, as far as a chancellor can instruct anything in Germany, the Ministry of Economy to develop the BMWi contract. I was selected to be the chair, as I'm still today here, of that working group. And the decisive change between BMW I contract of 2007 and the Berlin contract of 2001, 2002, which came into force 2003, was that now this lump sum solution could also be chosen. That means that you sell the invention coming out of the work of the university, financed by industry, can be sold and should be sold and thereafter solely owned by the industry partner. And if we now look at page, please, 11, comes something very important, what was developed in the years thereafter and led to the today still applicable version of the BMWi contract, that in order to come into conformity with the EU regulation, we had then a representative, Mr. von Wendland, of the European Union permanently in our working group in Berlin, working on the further developments of the contract, is that if whatever the university gets from industry for this research work, which is done by university, financed by industry, that an arm's length price is paid for that. That means either the royalties, if royalties are paid in case of commercial use of the results by industry, has to be in conformity with arm's length contracts between reasonable parties in a similar technical field, or that if a sale takes place, that means a lump sum is paid for the transfer of ownership, of the full ownership of the university-based invention is given to industry, that this is practically calculated as the net present value of otherwise achievable licensing income of the university with that industry partner. Only then this is in conformity with the European Union regulations, which otherwise would see in a lower price which the university would take from industry, a prohibited support of public research institutions, which would distort competition between various organizations, also in other European countries, but even in Germany, working on industry-university cooperative R&D, because it would then make the price the university would charge cheaper and or lower, and this would be prohibited. Except university sells as an alternative also to industry based on a full cost calculation, but there's only one university in Europe, or not in Europe, in Germany, which is Erlangen-Nuremberg, generally very, very closely related and cooperating with Siemens AG, who use this full cost model, that you pay, that you divide practically, not only practically, legally and practically, at university an R&D budget from the teaching, etc. budget, the latter not being influenced by these considerations, but the full cost approach has to be applied to the R&D budget of the university, and they cannot sell cheaper to industry. Where do we stand today? This is the last of the slides I wanted to use. We have today, a week ago, we had another, maybe not as never final, we have these sessions every 1 to 2 years at the Ministry of Economy in Berlin. It is me chairing these sessions, but it is two famous cooperators in this academic part of the further development, Professor Szyszowski, former partner of Böhmert & Böhmert and dear friend of mine and a close cooperation partner of mine in that project, who from the beginning of the Berlin contract worked with me on all these things, and Professor Sebastian Wündisch, who is particularly active he belongs to NER, Stiefelhofer, and is a professor at Dresden University, who is a specialist for consortial agreements. And now the latest development we have taken is a new version of the BMW I contract, which will come out to the public in the next 6 or 7 months, before mid of next year at least, which not only handles situations between one university partner and one industry partner, what is the content of all these Berlin and BMW I contracts, master contracts or model contracts, but which is now applicable also if there is more than one university involved, 2, 3, 4, and 5, whatever, and more than one industry or more than one industry partner, 1, 2, 3, 4, 5. This consortial agreement is now finished. We had a day-long session last Monday in Berlin with the ministry always. They accompany the whole process, and we hope to be able to present it to the public somewhere in February, probably in a presence meeting in Berlin again, where then the interested public will be confronted with the result of all these consultations. To cut a long story short, we have in Germany no full professor's privilege for university inventions. We have a partial professor's privilege, which is regulated by the fact that the professors have the right not to publish, a constitutional right. And we have model agreements, the most advanced ones, as if I may say, in all modesty, and completely continuously developed by a consortium in which, for example, there sit BASF represented here today, there sit Edgar Luschel, is to be praised for that, a very particularly active member of Schaeffler Continental Group, absolutely great input. Bayer is there, other companies, Bosch is there, SAP is there, Siemens is there, not the least also universities like university representatives like from Provendis, like from the German Rektoren Conference, that is the conference of heads of German universities, and always observed by one person from the European Commission, Mr. von Wendland at the moment, and we hope to come out, as I said, in a couple of months. Purpose of the whole thing is to make it cheap and easy for university and industry partners to conclude cooperation agreements at a very early stage. And it is all due to the fact also that in Germany, according at least to my personal observation, we do not have a cabinet licensing market where universities would independently develop inventions and then offer them to industry. Would you like to license them in? Nice price, nice invention. We have practically a cooperation market. And one of the biggest tasks in so far for the German legislator is to create a, let's say, a searchable map of the German universities where also small and medium-sized industries can see what university or which university, which professor is working in certain technical fields. One can see this from statistics, from data from the patent offices at EPO and GPTO, for example, because they have the data of all patent applications pending there, that a small company, let's say a bicycle manufacturer of a place near Bremen, where I am today, near the Dutch border, Kloppenburg, they can see, who is working in Germany on strengthening of ceramic brake parts for bicycles. I need to go to, just an example, Cottbus, to that professor. They work on this, they have worked on this. And then these cooperation agreements are concluded, which generally predispose of the right to use and the conditions thereof of the inventions which come out of such projects. That is all I have to talk about, and we hear possibly, hopefully now, by somebody from industry, or two persons from industry, how industry accepts this situation, how and by whom these model agreements, which are all in a modular form, all voluntary, no reason not to put the modules together in a different way than the guidance which the Ministry of economy publishes always together with the recent versions of the agreements are used in practice. I would like to refrain from any comments thereof, but I know, for example, that BASF has been right from the beginning a promoter of the use of such model agreements, which can be modified. They are always modified. The big companies, if you ask Siemens and they go to Erlangen, they don't need the model agreements. This is a long established business of two cooperating entities. And I would be sure nearly, at least I think so, that companies like BASF and also, of course, like Schaeffler Group will have similar arrangements. I know, for example, for German car industry, the Karlsruhe Institute for Automotive Industry is very, very active in industry cooperations. I personally think always that most German cars, 80% of the components or whatever thereof is made in Karlsruhe out of cooperations of this type. Maybe I'm overdoing, but it's a little bit like German Automotive Incorporated Research Center, which you find there. That's all. Thank you.
Thank you very much, Professor Gadar. Maybe some words from the industry to add something on professors' rights, maybe students' rights. Later on, I'm going to talk a little bit about the Russian experience, and we can talk about different angle. Dr. Mayer, would you like to add something?
Yeah, Heinz, thank you very much. This was all correct because you're in the field for many, many years, and I guess one of the most experienced contract writers there. But it was difficult in the beginning, no doubt, right? All the parties kind of confused after the change in law, and people were really concerned. Are we really allowed to conclude this kind of agreement, or is it void after? So this was, well, maybe not a big risk, but there was uncertainty in the field, and the model agreements were most helpful in giving some guidance, especially to those universities not really experienced in the field of negotiating this kind of agreements. So what we found over time is, well, we all got used to it, and with these relatively low payments for the patents, be it one lump sum or be it two payments, it doesn't matter in the end, you could live. And when you look, now we have to differentiate between the industries. From the chemical industry, life is relatively easy within this framework. You have these payments for the inventions made, that's fine. You can file the priority application, as you said, with a co-applicant or a university. Then you are free to develop your own patent portfolio as you think is right for your business. And then you have kind of open end and say, well, we are going to negotiate a real license in case of commercial success. But when you look at the rate of commercial success from university inventions in chemistry, this is relatively low. So you can run this risk from the business perspective, open end. You don't know what you will have to pay in the end, because the number of cases is relatively low. This is different in automotive industry. As you said, this is kind of a co-development center at the universities or other R&D centers, publicly paid. And the number is so much higher when you add up the potential license fee in the end. This is nothing you want to sell to your upper management. So, of course, the approach has to be different. And I fully understand the colleagues from this industry that they try to pay a lump sum and then it's done, because then you're on your own with your business and anything is set for the future. So, as I said, you have to differentiate between the industries, but I think both industry or all industries have found their way through, and those times are over when you turn to a relatively new or small university that they try to insist on the model agreements and say, we have to do it like this. No, this was never thought like this. There was always flexibility. You can mix them up. You can add clauses, whatever you think is suitable, but that's negotiation. You're used to or not. And the problems still result, or at least resulted in the past, from lack of experience and kind of fear of leaving the solid ground of the model agreements and doing something on your own where you don't know, well, will it really be to my benefit in the end or not? But this is, well, typical negotiation, convincing, trusting, and this kind of thing. In the longer we have those laws in place, I think most industries have developed their way through for the standard situation. So this is no longer a threat, I think.
Thanks a lot, Dr. Meyer. And I have another question. Professor Godard mentioned that universities themselves, they do not participate in licensing scenarios as such, because they usually prefer industry to stand as a licensor, or because under certain agreements you mentioned, they do not have exclusive rights to offer. So the question is, the university technologies which are licensed, are they in certain instances differ from the other R&Ds that are licensed in Germany? Are there any peculiarities or certain things that lawyers should point out when university-based technologies are licensed by the industry?
Yeah, I'm happy to comment on this briefly. We have this the Berlin contract originally was only between universities and industry partners. Now, the BMWI contract in the form of 2007, as well as the modernized versions like the one which is now in preparation and will come out very soon, they are also including research institutions like Max Planck Gesellschaft, like Fraunhofer, like Helmholtz. These are famous German research groups, the research institute groups, who also have participated and are continuing to do so in the further development of the model agreement. So this is something which will not only apply to research institutions, but also institutions at universities, but also to other non-university research institutions. The principal question is always, when you draft contracts between a university or public research institutions, an academy of science in China or whatsoever, and the industry partner, is always the following. The industry partner, even if he only contributes to the research which is done at the university, wishes to fairly pay for this, but they wish at least to have in their core field of industrial interest an exclusivity. And so usually, whatever the agreements are, there is a certain field where industry has exclusive rights. That might be a very restricted field. It might also include clauses that if the industry doesn't use this whole thing for more than 2 years, if certain thresholds in turnover, etc., are not achieved for a certain time, that then the exclusivity might expire, and the university is then, or public research institutions, entitled to grant licenses, non-exclusive ones, to other parties, or even exclusive ones, but always saving the right of the financing project partners. This is very often a development over time. So if a lawyer, if a patent attorney, your firm, many firms, academies and science in Russia negotiate and draft such agreements, it will also be these 2 points. How far should exclusivity, and for how long and what conditions, for at least the technical core field of the industry partner, the financing partner, go? And what would be the conditions to maintain the exclusivity, and also what would be the right outside of that field? A typical research institutions like Fraunhofer, and this is public, so they tell you in each and every session where they participate in the public, their business is licensing. That means it is very hard, so not impossible, I must say, to negotiate with them exclusivities for certain industry partners for certain technical fields. But outside of these fields, they wish to be able to sell, to license out, to work with other parties in relation to a certain invention made. But these are the only critical points I always see. It is whether licensing or selling, where should exclusivity be, how long should it last, and under what conditions, and furthermore, what would be the right and duties of university or other public research institutions outside of this technical exclusivity field, because there also might be restrictions that university should please not license out to direct competitors in certain fields, to the cooperating industry partner, etc. But these are about the critical points I would have on my table, and Christian and always, I think also our industry representatives here when they negotiate agreements of this kind. These are the typical ones.
Thanks a lot. And I have a final question, I think, before we move forward or before industry wants to add something. You mentioned the joint ownership, joint filing, and joint patent acquisition.
Yep.
In this type of scenario, when university and industry will own patent, what are things to remember when they license this out to someone else?
Okay.
How royalties are split, how rights are allocated? Can you talk a bit on that?
Yeah, I mean, there you have essentially contractual freedom as long as you observe the principle that the university must pay out of the BRAT of the what is the English word? Yeah, maybe BRAT income must pay 30% to university because that is must pay something reasonable to university because that is the basis for the 30% of the remuneration, which in a binding manner the German university inventors get. And it is well to be observed that when a project financing is agreed on between industry and university right from the beginning, to clearly say this component of the overall project financing, let's say of 10 million euro, only this 10% of it, this 1 million, is for potential inventions, etc. Because based thereon, the professors later on get the 30% share, which is their remuneration for the invention. And I have seen many conflicts that later on the dispute comes between the university-based inventors and the universities and the industry partner equally, where practically the professors say, if they are well represented by capable patent attorneys and lawyers, practically everything was only paid for the future inventions. So we get 30% of the total project financing. And the university is usually of the opposite opinion, together with the industry partner. No, a minor part thereof was for the inventions, and 30% of that goes to the professor. So this can be a very important point to negotiate, the basis for later on calculating the 30% we are talking about.
Thank you. Maybe some questions or comments from the industry. Dr. Mayer, would you like to comment on licensing issues?
Well, just a general observation, the purpose for the new law in 2002 was to strengthen university and to build something up like a licensed community. Well, we all looked at Harvard and MIT and those really successful US university, and this entirely failed. I mean, this is not what we got. As Heinz said, we see a lot of corporations, but we do not see those successful university license offices where you can turn to and say, well, this is something I'm really interested in. And one of the reasons it's really complicated, the entire situation with the special payment to the professor. Nobody really needs this. This could be solved in a different way. If I really want to strengthen university, I focus on the university and not on the professor as a person, quite frankly. But anyway, that's too late. So we have the situation as it is. And from outside Germany turning to the German universities, you will run into these questions, those model ideas and things which are workable, but could have been set up in a different way.
Absolutely. I fully agree to that. I must say, I'm sometimes asked, is it better since the new law, 6th of February 2002, which had a 1-year transition period until 6th February 2003, where still many inventions were made under old consultancy agreements. But anyway, is it better or worse? I would say it is worse for the tradition of industry-university cooperation, which worked pretty well in Germany beforehand, under the professor's privilege, and I would not see any problem if you would have a similar thing still today. The only thing which has been achieved to a certain extent is that inventions which otherwise would not have been properly handled by universities and professors, they simply didn't know what to do. That means small universities, unexperienced industry partners. These inventions could be, if properly handled, dug out, because at the same time when the law, this is sometimes overlooked, certainly not by Dr. Meyer and Dr. Luschel, but at the same time when the law came into force, the loss, if you wish so, of professors' privilege, I always must say of the full professor's privilege in Germany on the 6th of February 2002, came the law which made it compulsory for all German universities to have a technology administration office or transfer office or whatever you call it, let's say a patent department. They could have it alone for their own university. They could have it in groups of universities. They also could have it for technology clusters for all over Germany, biotech inventions, maybe today mRNA vaccine inventions or whatever. This is all possible. And the government used a substantial part of the money they squeezed out of the telecommunication providers and companies for selling the UMTS licenses, that is 2G plus, etc., that they took 200 million or something, 209 million or so, and gave it as a starting money to the German university to establish what they normally didn't have, a technology transfer or patent administration office. That money ran out somewhere. There came an extension of it, but then only for certain of these offices, but at least. I personally do not know of any German university, even the smaller ones, even a law school in Hamburg, like Bucerius Law School or so. They all have their, let's call them TTO, technology transfer offices. And they are used in this case for unexperienced professors, for little inventors who don't know what to do. There is a patent department they can go to, and they can send them either to freelancing practitioners, to patent firms, they can direct them to industry and whatsoever. And before the 6th of February 2002, those who didn't know, they let just their inventions go somewhere into the waste bin, and nothing happened with this. But this is a very small percentage of the results of R&D at universities. For that small percentage, whether it then was necessary to build such a, one could say monstrous law even, as we have it now, is a big question. Thank you.
Thank you. And I think we can we have another 10 minutes to talk on Russian experience, and I would be glad to make a small presentation on the Russian approach. So please, here is the presentation. So these are the few things that I want to talk about. First, I would like to announce that in June this year, a Russian government promoted a decree on promotion of technology transfer centers, and we will talk briefly about what are these centers about and why this initiative was proposed. We'll talk about a bit about university inventions and rights, since the approach, which I understand in Germany, is very similar to Russia, although the practice is a little bit behind German system. Then we'll talk about the legal scenarios, how the rights can subsist, and a few words about IP licensing practice in Russia. So let's start from the technology transfer centers. So the government decree was proposed in June, and the decree provided special rules for competition and tenders, so that to acquire certain grants on subsidies from the federal state budget. This is exactly what Professor Godard was mentioning by history, but we are coming to it now. Of course, it doesn't mean that in Russian universities or scientific organizations there were no R&D centers in the past. We had that, but now the government wants to put it on another level and wants to promote IP and IP commercialization. And of course, this has nothing to do with the industry, but of course with the university, since all universities and they have a certain R&D centers. So there were 18 winners at the beginning, including different universities from different industries, medical industry, digital industry, engineering, and others. You can see the short list on the slide, but 18 universities, they won the first competition, the tender, and they will receive for this year more than 300 million rubles as grants. There is a certain procedure, and the Ministry of Education is involved. They have to approve the application, etc., and the documents. And we hope that these universities will spend this money not on their needs, but on real IP promotion, on receiving new patents, on concluding different agreements, including on the international level, since under these subsidiaries they can make international patent filing, receive international patents, and they can be involved in international licensing scenarios. By 2025, we expect to have 35 centers established. That is the plan of the government, and I can repeat that government wants to put these R&D centers, or new name is technology transfer centers, on the new level. By the way, Mr. Godard, can you do you have an idea how it will work in Russia? Is it the same way like in Germany, or do you think we can have something new and different from Germany?
The only thing I can say on the experiences with the development of the system in Germany since 2001, 2002, when this first initial injection of money took place.
20 years ago.
Yeah, well, no. It developed in such a manner that what you have today still is that you have cluster-related, technology cluster-related, successful technology transfer offices and regional ones. That means this idea that each and every small university, maybe the Russian universities are much bigger, needs its own transfer office is possibly not the right way, because such a technology transfer office, if it really should transfer technology, needs to have certain contact people who have experience with industry and can talk to car industry, to that manufacturer, to this one. And we have seen this in Germany as very valuable, that you have a little bit bigger transfer offices which can serve then, if they serve several universities, also several parts of industry. And for that, I would say a concentration of these centers, maybe regional, though this might be in such a wide, large country like Russia difficult, but then maybe for certain technologies with specialized technology transfer offices might be the better way, which immediately needs then, of course, branches of these technology transfer offices. If it is only one person per university which sits in each university, that you have a short way from inventor, R&D, doing people, laboratory, to the respective contact person, which then can transfer this whole knowledge then and to start the process with the center. So bigger centers with branches or individuals serving certain universities, from my viewpoint, would be better if the money would be used for that, because then you can also attract more professional expertise by IP firms, by outside experts who could help that specific technology center, even with specialists for certain industry, whether it is polymers, whether it is biotech inventions, whether it is telecommunication, etc. Yeah, thank you.
Including patent attorneys.
Yeah,
So I think we are on the right.
I omitted them because they are usually pretty expensive. So you might have patent engineers who can do in these industry centers, I think, a very valuable job already. If they draft in-house, let's say, in-house in such a technology transfer center, you will have a different organization. They should be the junction between the transfer device between university and outside attorneys. But if they do all work themselves, that would be difficult. I think that these transfer centers need outside help, and drafting is first thing I could think of that they should not do in-house. And typically in German university technology transfer centers, they don't do this in-house. They use patent firms outside. We do also, but not only my firm, many others work for, whether it is Fraunhofer or University of Erlangen or University of Karlsruhe, KIT, or what it is, Karlsruhe Institute for Technology, etc., etc. So I think the patent attorneys themselves are a little bit, I would not say overqualified. They are in the wrong direction qualified to work. Maybe one per transfer center is okay, but to do all the practical works there, that should better be outside. The transfer center sits in between, must understand the technology, must on the other hand be able to market the technology. That means needs experienced people from industry working there, and not all of them, and possibly not even the most qualified ones, are patent attorneys, but are technology specialists known in industry, knowing industry, and know how to use the right IP specialists from outside of this transfer center.
Okay, thank you. So we will follow your practice, and maybe we will implement special programs for these institutions, not pro bono, but special fees, so that we can also move our profession to a new level. And if you read, by the way, the list of these winners, a lot of them, most of them are not located in Russia and St. Petersburg. This is Kazan region, this is Siberia, this is Vladivostok. So all this, the southern part of Russia, these universities are spread all over the country, and we hope this may change something for IP in the
Thank
future.
you. I think that's a brilliant idea. This is this localization, which I saw. Certain regions,
the regional approach.
Yes, but my knowledge, unfortunately, of Russian geography did not allow me. I have understood or saw Tomsky. This could have to do with Tomsk, Omsk, Tomsk. These are cities which go far beyond Moscow to the east from Germany, but the others I simply didn't know. So very helpful. Thank you.
Yeah, if you need, we can send you the list for your reference and for your knowledge.
Yes,
so let's move forward, since the time is of essence now, and let's speak about rights. As Professor Godard mentioned, universities in Russia are not usually stand as licensors. Usually they are the contractors for certain customers, for certain organizations, for certain businesses and industry, when they have laboratories, when they have R&D small centers, and these companies would order some technology from them. So when the IP is created, in these particular centers, this IP is transferred under contract to these industry people. But we have to remember about two things. When the professor is hired to work in the university, they would usually sign an employment agreement, or they would usually sign a special order of employer, the university, under which all exclusive rights would belong to employer, i.e. the university where he is working. But interesting thing came to my mind when I was preparing for this presentation is about student rights. So, we usually think of professors when we talk about university rights, but in many situations, students can create something during their lectures, during or after their lectures, when they are educated in the university. So these people are not usually located in the employment relations. They would usually they will be usually studying in the university and listening to the lectures, but not creating any lectures. So usually, if there are no employment relations between the student and the university, which is usually the case, the object of patent would usually belong to the would not be treated as the employee invention, and hence what they create will be owned by themselves.
Yes.
So in Germany, is there a special rule when the invention is not created under the employment relations, but the university will take something from the invention?
This was one of the biggest problems we immediately realized, even when discussing the Berlin contract in 2001, 2002 already. I said then, I still remember, and it was published even, the most dangerous inventors in these configurations are students, because we need to catch them. And I recommend it, and you will find this as an attachment to the model agreements, both Berlin, but also BMWI contract, that the first thing before you allow a student even to put a footstep into a laboratory, which works in this concept, that they sign something like the following. There are samples of this. The student agrees that all inventive contributions he might make during the work in this internship, etc., belong with factual effect from the time of their creation to the university or to the professor. You can do both, or one of them, of course. And you must also never forget, this is important in the German labor law, that the compensation for this transfer or assignment of these creations is already concluded in the allowance to work on the project in the laboratory, period. So there is a form for that. There's a model agreement attachment. Very, very important. We would have, in other words, to make it short, a similar situation in Germany like you have it in Russia. Exactly the same thing.
Okay, and the other scenario is when again someone will order something from the university, from the institute. So this the special provisions of Russian Civil Code will apply when university and industry, they face each other in the R&D contract or special technology contract, and they will allocate the rights usually in favor of the business. The university will just stay with the non-exclusive license, which can be royalty-free and granted for the period of the patent. So this can be shown in this table. Basically, the development of the technology which is created in the university can be two phases: the employment phase or the civil law phase, which we called business relations. In the employment phase, the university, when they order something from its employees, they have to remember 4 months period when they need to file an application to assign patent rights or to put it confidential to avoid the transfer of rights to the employees, and this can happen in practice. In this business relations scenario, when the university and industry, they sign a contract, it is vital to remember the language of exclusive rights in this contract. When the industry signs, they have to make sure that all exclusive rights to all inventions, utility models, maybe software, maybe designs or something that is related to this specific industry, like Mr. Godard mentioned, the exclusive rights have to arise with the customer. And again, by default, the university can retain these rights if we put nothing there, and there is no order of specific technology. The developer keeps all rights by default provision of law. Of course, in this case, the customer reserves the right to receive license, but some paperwork is always recommended when this license on specific terms is assigned in addition to the development contract. And a few things before we end up this conversation, since we are end of time and we need to close this roundtable. Few things on licensing. The licensing is pretty much same as in Germany, because we follow the German approach in all our laws and practices. So we will have patent license agreements, patent and know-how license agreements. We will have tech transfer agreements when the technology is fully assigned to the contractor. And speaking about the licensing objects, this can be again patents granted on the territory of Russia. For example, you cannot license the German patents in Russia, since patents as always territorial principle. Know-how is also which is surrounding patents can be added into the license agreement. It can be a mixed contract. Software we see lately in all the contracts, because a lot of digital technology is appeared, so we would usually have software and databases in all these contracts and all other rights. I would skip one slide on legal definition and speak about these essential elements which has to be in the contract on in the license agreement, whether it is university-based agreement, based technology agreement, or something other like R&D technology, for example. The subject matter is critical. You have to have patent registration number, because again, we need to have the Russian granted patent and specify it exactly in the contract. The type of license which Professor Godard mentioned, I mean, the exclusivity is very important, because exclusive rights, they give absolutely more rights than in non-exclusive licenses, especially, for example, from the standpoint of enforcement. The exclusive licensee, which is recorded, of course, recordal is another topic. They have rights to enforce against infringers like it was the patent owner. So they need to show the registered license in the court to prove its rights. Permitted scope is another important element. You have to define exactly for what particular use you want to license your patent. Is it manufacture? Is it just sale and offer for sale and sale? Is it application? Usually it's the question of negotiations when we practice license agreements. Well, territory and term, I'm not going to stop here, since it is very close to German approach. These things must be specified, and specific language on termination must be provided. A few last things on registration, and I'm gonna roll up. So every patent license in Russia is subject to recordal. Non-recordal makes it non-valid, especially against third parties. And recordal is very formal. You don't need to disclose original agreement. You can file the short statement or excerpt to keep certain things confidential, or keep the sensitive information confidential. You have to file with Rospatent, the registrar which granted the patent before, and the procedure is very quick. It's almost 2 months. In case of no FS action, you can receive the license recordal, which again validates the license relationship between the parties. Thank you very much. We are 10 minutes behind behind our schedule. Maybe some final questions and other questions can be asked via email. Well, we have a question of Alexey Kalinchenko. Dear colleagues, please share your observations. What is in practice of distributing rights to an invention and royalties if an author of the invention is not an employee in the institute, but a student? Well, I think we covered it, and we can skip it. And Alexey, you can email Godard or me in person just to save time. Please comment about practice of remuneration paid to a university. In particular, what are basic principles of calculation royalty payments, especially in the products many inventions are used? Godard, would you like to start?
I did not understand acoustically, yes, but I did not fully understand. Can you repeat your question, please?
Yes. Practice of remuneration payment to university in particular. What are basic principles of calculation royalty payments, especially when in the products many inventions are used?
Yeah, thank you. This is one of the easy questions in patent law, of course, and licensing practice. I can only say the following. We have a still widely used formula. I heard it yesterday, actually on Friday, in an event of LAS Germany, where Alisa Zeller of BASF said that the good old Klospe formula is not bad to come to a first approximation of what the height of the royalties should be. So typically for me, and this is where I start my considerations, is always that the licensee should pay about 25%, maybe between 20 and 30% of its profit margin to the licensor as royalty. That's the basis. Then it can be higher, it can be lower, it depends on the circumstances. If there are many inventions, it comes all at the end of the day of German Employee Invention Act and the voluminous case law and arbitration proposals, cases coming out of that, of the GPTO according to German law. If there are several inventions, well, then you have to look at a certain provision in the rules how to calculate employee invention remuneration when applying a license analogy, namely the principle that the stacked royalties on a product which would then appear if there are, let's say, 10 inventions by 10 different owners of inventions are considered, that the stacked royalties do not reach such a height that the product practically becomes unmarketable. I had a personal experience in 2003 with a company I mentioned several times today, who at that time was in telecommunication business, where in 2G technology, actually the stacked royalties came to 52%. And this is pretty high. The product is not marketable anymore. And this was considered, unfortunately, by certain people in Brussels as being anti-competitive and not possible. And they need to agree on different things. So you must look at the inventions which are necessary, and you must look what maximum royalty could be applied to that product, and then you must distribute it after prioritization to the various patents involved. A rule of thumb which might help is that under Fritz Teufel, still long time ago, when he was head of patent department of IBM Germany, they had the rule that if you have doesn't matter how many patents of that company, IBM, were involved, you had a maximum cumulated or stacked royalty of 5%. And if there were 10 patents under it, it was 0.5% per patent. If it was 2, it was 2.5, etc. My personal rule of thumb is, if you have determined a marketable royalty, let's say, according to this Klospe rule, 25% of the profit margin, maximum twice of that is the end of that is the ceiling. Otherwise, the product becomes unmarketable. So if you have one patent, it is, let's say, 10% royalty to make it easy and to comfort pharmaceutical industry with their giant profit margins sometimes for blockbusters, etc. I don't wish to enter into a fight with pharma industry. I do the enough. So I would say if it is 10%, it is the normal royalty, then 20% would be all of it. So whether we have 10 patents, 100 or 1,000, it has all to go under the ceiling of 20% in this case. Thank you.
Thank you, Godard. Thank you, Mayor. Thank you, all our speakers. We had again today the terrific panel of speakers. Bernard and Bernard, Les Germany, other companies, including Gordiski. Thank you very much for being with us today. We hope we were of help to everyone. Of course, if there are other questions, please email it to us, to Gordiski, and we will distribute to our panelists. And we hope, like Yuri mentioned, we hope we will repeat this session next time in person, because everyone is tired of pandemic. So live discussion and person discussion always make it more professional and more attractive. So we hope we will sit and discuss these topics again next year. So thank you all and have a great day. We look forward to meeting you again tomorrow on our trademark session.
Yeah, thank you so much. From my side only, I remember wonderful seminars which since the foundation of LAS Russia in 1995-96, you have organized in Russia. It was always a pleasure to be there. I miss really for 10 years at least not to have been in Moscow anymore, nor St. Petersburg. I hope that future will make it possible again to travel. It was LAS Russia essentially, not the least promoted also by your firm and the founding services by Mr. Gorodiski himself, late Mr. Gorodiski, dear friend who is not with us since a long time anymore. I hope that these times come all back, and it was always a great friendship we could experience as LAS Germany, where I was in the early years of my presidency in LAS Germany, active in this regard, particularly to build this LAS Russia based on experiences in LAS International Conference Berlin 1993, when I was first approached by some participants also of today, and I hope it will come back. Thank you so much.
Thank you, Professor Godard, and have a great day, everyone.
Bye-bye.
Thank you, everybody. Thank you. Our pleasure. Bye-bye.